Yes.
I beg to pray for listing of a repetition, Lordship. That was filed on 6th of May. The matter pertains to the transfer of the repetition.
Transfer?
Pertains to the transfer.
We'll have it on Wednesday.
Lordship.
You want it today?
Lordship.
Not possible.
Yes.
Okay.
I have left the file. I have left the record in my chamber.
Huh?
Today I have left the record in my chamber.
Just 1 second. Hey. On
Wednesday, my lord. On Wednesday.
Wednesday.
Yes. Thanks.
Please, Your Lordship. My lord, item 43 and 44. These are motion matters, my lord. But wrong shown as my lord in the order column. My lord. To content
43.
43 and 44.
Okay. We'll have it on motion. Huh?
My lord. Highly obliged.
What about 42? Same.
43 and
My
44.
lord, 42 is same, my lord. I'm
Same, na?
my lord.
Okay. 42, 43, 44 after this.
Obliged.
Paying for listing, Lord.
Hmm?
For paying for listing or admission from Lord. Paying for listing of a case first admission, Lord.
Why?
Some urgency is there, Lord.
What is the urgency?
Urgency is plus because person who has been selected plus was wrongly selected, that's why this petition has been declared. So the
A person has been selected. And then?
then this petition has been declared on it is second
When was the petition filed?
23, Lord. 23.
Then? Why, no interim orders?
Already they were appointed, Lord.
Then? Why do you want it for admission? It will come in its course. Has the affidavits been filed?
No, Lord.
Then we'll have to wait.
If matter is not listed, it will not stop automatically. Lord. They will not file.
Chalo.
In next week, Lord, I'm paying for only next. Paying for the next week.
Okay, we'll have it on 15th.
Lord, I have 15.
15th.
Problem.
Wait, please, Your Lordship, I beg to mention for late things.
That day? Yes, tell me. Now you got your reason?
He's facing their financial crisis and he's facing their financial crisis and finding it very difficult to run his family and even
No pension.
maintain his day-to-day expenses.
Chalo. We'll have it on 15th.
Apply.
Please, Your Lordship. The documentation for listing for withdrawal of matter will be listed tomorrow.
Okay. You want it when? 10th? For withdrawal?
Yes.
Okay, on 10th?
Please.
Yes, have you got it?
The records I'm sorry.
Tomorrow I'll hand it over, Mr. Kyle, back to you. Okay.
Delhi Sentinel 1 for motion.
Please, Your Lord. Lordship, matter pertains to selection and appointment of Gaumbuda's member. My lord, we have challenged the impugned select list dated 10/11/2022. Page 35.
Okay, 10/11/2022.
Yes, my lord. Page
Why?
35, my lord.
Why? 29?
29.
29 page.
Yes, why have we challenged?
29. My lord, because my father was a Gaumbuda, earlier Gaumbuda man.
So that is a consideration? Now, is that a consideration for appointing you as a Gaumbuda?
My lord, there is a rule.
Hmm.
Executive instruction, my lord, that provides for, my lord, 162A, my lord, executive instruction, land laws of Assam, my lord.
What does it say?
My lord, it has given 3 factors which shall be taken into consideration while
land laws
appointing
of
in Gaumbuda, my lord. First factor is that, my lord, the claims of the family members of the Gaumbuda. The present petitioner, my lord, is the daughter of the
Just 1
Gaumbuda.
minute, just 1 minute. 162.
Page 408.
162A, where is it? In the rules, where?
408, page 408.
Which book?
Then law.
This one? Same?
Yes, ma'am.
Page 408.
Executive instructions, my lord.
408. What is it? I don't know.
I have annexed it also, my lord, to the writ petition, my lord. Annexed
You have
6, my lord,
annexed it, just one second.
page 37.
Page 37.
Yes, ma'am. I have annexed.
Yes. Shall be
The three
appointed to
vectors are
defend the
as follows.
in the case of so and so. It shall be okay. Now
Now the petitioner.
you come within the ambit of A1,
Yes, my lord. A1, my
the claims of the family of the Gambura.
Yes, ma'am.
What is that claim?
Claim is that, my lord, she is the daughter of the Gambura,
So,
earlier Gambura.
so it has
So
a
she has filed one representation also before the deputy commissioner, my lord. At page 40, my lord. Page 40.
now who have been selected?
My lord, respondent number 6, Hazrat Ali has been selected by them.
Respondent number 6.
6, my lord.
Page. Which circle? Which cow?
It's, my lord, Bassa Simolu, Majuli Char 1 to 3.
Where is it? At page 29, which one?
My lord,
Who has been selected?
my lord, page 35 is the relevant portion, my lord. Serial number 15, my lord.
35. Serial
35.
number?
Serial number 15, my lord. Borsola.
Oh,
Number 1 and 2, my lord. This is
Okay.
Hazrat Ali, my lord. Page 35.
Hazrat Ali.
Yes.
Okay. So you claim that you should have been appointed as a Gambura.
Yes. Moreover, my lord, I only have that much fear that, my lord, respondent authority may dispose of my representation. I have filed it at this.
But can it happen? Disposing of a representation would help you? With an order passed on 10/11/2022, without that being set aside,
Yes, ma'am.
can representation will help you?
Then, my lord, taking into the consideration, my lord, this practice, my lord, my case could be considered by the respondent authority. The direction may be.
For what? For consideration.
No, my lord.
Then,
For setting aside that, my lord, impugn.
okay. Now this person concerned, Hazrat Ali, he is a party here.
Yes, my lord. Respondent number 6.
And why have you challenged this after 6 months?
The petition was filed, my lord, on, my lord, 6/1/2023, my
6/1.
6/1, my lord.
Nothing has happened.
No, they have taken adjournment, my lord, on earlier
On
occasion.
earlier occasion, adjournment was taken, my lord.
On the request made on behalf of Mr. S. Upaidya, list the matter after 2 weeks.
Yes, my lord. I was unwell, my lord.
Now we are after 9 weeks. Yes, madam. Tell me.
Lordship, may kindly have a look, page 24 for a moment, the advertisement, my lord.
Page 24. Yes.
Serial number 6, my lord, minimum qualification of the candidate, and 6 is relevant. Preference for appointment will be given to the family members of the Gaon Pradhan, and this regard, the opinion of the Mozada will be taken into consideration. Only preference is given. If the marks is equal in 2 to 3 candidates, then only preference will be given to the Gaon Bhas family. It is the advertisement process, and after the advertisement, the private respondent has been selected, and he has been appointed, my lord, as per the order, page 29, in the month of November. This to lordship may.
Okay. Heard, Mr.
Yes, Upaidya.
S. Upaidya.
Yes.
The learned counsel appearing on behalf of the petitioner, Ms. M.D. Bora,
I am for
appears,
3, 4, and 5, my lord.
appears on behalf of respondent numbers 3, 4, and 5.
My lord.
Mr. S. Doctor appears for the respondent number 1,
1 and 2.
1 and 2. Issue notice making it returnable when?
As per lordship and
I'm not here to say much on the convenience because this is a temporary bench I'm taking. Yes, when?
3 weeks, 3 weeks,
We'll have it on 31st of May.
my lord.
Issue notice making it returnable on 31st of May 2023. As the respondent numbers 1 to 5 are duly represented by the learned counsels, extra copies of the writ petition be served during the course of the day. In respect to the respondent number 6, steps be taken by way of registered as well as usual. You want an early disposal?
Yes.
The petitioner is further directed to take steps upon the respondent number 3 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that in pursuance to an advertisement dated
10, 11, 20.
7/7/2022,
7, 7, 20.
the petitioner had applied for the post of the Gambura in respect to village 1 number and 2 number Basi Malu Mazuli Sor 1, 2, and 3. It is the case of the petitioner that the respondent authorities have, by the impugned order dated 10/11/2022, had appointed the respondent number 6 as the Gambura of the village in question without considering the claims of the petitioner, who happened to be the daughter of the erstwhile Gambura,
Earlier Gaon
earlier Gambura. The respondents shall apprise this court on the next returnable date as to why the petitioner's case was not considered.
My lord.
I'm
Deeply
highly
obliged.
obliged.
I know two.
It is Lord.
Yes.
Here, my lord, the state level committee, my lord, had not recommend our cases due to, my lord, want of vacancy, my lord, in the parent department.
Hmm.
So, my lord, the state level committee had, my lord, recommended to be adjusted in other department. For a lot, may kindly turn to page 37 for a one.
30?
37, 37.
37. Yes.
At the top, my lord.
Your
The-
name? Bima Bisposho. Binadeka.
Yeah.
Where is it?
My lord, Lord, may kindly see that the top, my lord, the remaining 11 numbers of eligible
Page
candidates.
37.
37, my lord.
Where is it? 4 numbers of so and so. Where are you reading? Remaining 11?
My lord, at the top, my lord, internal page number 11, my lord, 11.
Oh, page 38.
30,
The remaining 11.
yes, my lord, remaining 11 numbers of eligible candidates proposed for grade 4 post, along with the remaining 3 candidates proposed for grade 3 post. Total 14 candidates shown herein below could not be accommodated due to non-availability of sufficient vacancy, and therefore proposal shall be forwarded to the other department as per clause 15 of the OM dated so and so.
Then
Now, my lord, Annex 3, my lord. In my page, my lord, it is 39, my lord.
39?
39, my lord. Annex 3, my lord.
Yes.
My lord, there is an advertisement, my lord,
Who?
by the government, my lord. Lordship will see, my lord, near about, my lord, 13,000 posters available, my lord, for the
Hmm.
grade 4 post, my lord.
Hmm.
And this minutes was, my lord, on 13/9/2022,
Hmm.
and this advertisement is dated 25/3/2020.
13?
Advertisement dated
These
25.
minutes are dated?
The minutes dated 13th of September 20.
Very And it starts where?
Okay, it starts, my lord.
Yes, got it. Page 15.
Yes, my lord.
Animal husbandry.
Yes, my lord.
Oh,
Now, my lord,
for motion also they don't appear.
well, similarly, my lord, a case was moved before this court, my lord, last week, my lord.
Hmm.
And my lord, our order was given by a coordinate bench, my lord, issuing notice returnable, my lord, on 5/6/23.
Then
My lord, next date is 5/6/23. Same order, my lord.
what order?
My lord,
They just stay?
stay.
No.
No stay. No, nothing, no stay. A notice returnable on 5/6/23.
You only want a notice.
Lordship,
This
may I
is the
submit
order, my
one
lord.
thing?
Can I hand
May I
over?
submit, my lord?
Please.
The petitioner did not annex the DLC minute where their name is recommended by the DLC, because in the SLC minute their notice is not reflected. Page
SLC
37.
minute, they are not even.
Their name is not reflected in the SLC minute, but where is the DLC minute where they have claimed that they have been recommended by the DLC for the grade 4 post? DLC minute is not annexed in this petition,
No,
my lord.
page 38 is what?
Is there, my lord? It's
Page 37 is the SLC minute, my lord.
SLC 11, serial number 11. My name appears, my lord.
Serial number 11.
11, madam.
Ah,
Srimati
Bina
Bina
Bushra,
Bushra, madam.
alias Bina Dekha, page 38.
Yes, ma'am. Serial
Serial
number 11,
number?
my name appears, my lord.
Then they have to, then DLC have to take
But
a call, my lord, because as per clause 15, the SLC decided that they have to consider to other department. Then DLC have to take a call, my lord. Their name have to be placed before the DLC by the department, concerned department, because clause 15 is considered in the DLC minors.
Where is the DLC?
DLC is not.
DLC are not an ex, my lord.
You have not made the DLC part?
No, my lord. I made a SLC party. My case is that, my lord, my names were, our names were recommended by the state level committee to be accommodated in other departments. And in that, during that period, 13,300 posts were available, but our cases were not considered. That was a simple
But
case, my lord.
Mr. Doctor, don't you think that for the purpose of compassionate appointment, there is a particular quota in which it is to be filled
Yes,
up?
5%, my lord. 5%. Now the question before your lordship is that, my lord, the government has issued an advertisement stating there are 13,300 posts. Like, your lordship, may kindly see the advertisement
The advertisement was before.
before,
Okay.
and the results is declared tomorrow, day after tomorrow, the results will be declared, my lord.
Then
My lord, now the question before your lordship, my case is that, my lord, whether 5% has been reserved in these vacancies, my lord, 13,300.
no, whether some people in respect to this particular department,
My lord.
animal husbandry,
Animal husbandry, I could not be accommodated due to want of vacancy. I have nothing to say, my
now
lord.
these vacancies are for which?
My lord, all, my lord, there specifically nothing has been mentioned.
Different department establishment
Yes,
in the government of Yemen,
Yes.
in a grade 4.
So therefore, my lord, the coordinate bench of this court, my lord, on the last occasion has directed to obtain instruction to apprise this court to what action they have taken to accommodate the petitioner.
Now what happened on that day?
Not 5/6, my lord.
Or nothing?
5/6. That,
What is clause 15 of the OM?
clause 15 is that, my
Where
lord,
is that OM?
yes, and if there is no post available in the concerned department where he or she has applied, that their case may be considered in other department. I'm giving it as
Now who is going to consider that?
one of the state level committee, my lord, state, my lord.
If sufficient vacancies are not available in any particular office to accommodate the persons in the waiting list for compassionate appointment, is open to the administrative department with the office to take up the matter with the department to provide heard Mr. N.J. Dotto, the learned counsel appearing on behalf of the petitioner. And then, Madam, you are appearing for
Worship, I am
respond
for
number
only
one.
one, my lord.
M.D. Bora appears for respond number one. Mr. R. Putari appears for the respondent number three. None appears on behalf of the respondent number two. Their names have been reflected in the cause list.
No, no, ma'am.
You have served a copy.
Yes, ma'am.
Huh?
Yes, ma'am.
Name is not reflected.
Name is not. Hello.
None appears on behalf of the respondent number two on call. Issue notice making it returnable on 5/6/2023. The learned as the respondent number 1 and 2 is duly represented by their respective 1 and 3 is represented by their respective counsels. Extra copies of the writ petition be served upon them during the course of the day.
Fine.
The learned counsel for the petitioner further submits that the Animal Husbandry and Veterinary Department of the Government of Assam has a standing counsel.
And their names were reflected in the cause. Their names were standing counsel reflected in the cause.
Is it reflected?
Yes,
Not
ma'am.
reflected, my lord. Not reflected.
No, it's
Oh, no,
okay.
I'm sorry.
Not-
I'm sorry.
The learned counsel appearing on behalf of the petitioner submits that there is a standing counsel so appointed by the Government of Assam, Animal Husbandry and Veterinary Department, on whom at the time of prior to filing of the writ petition, copy has been served. He submits that the extra copy of the writ petition be permitted to be served upon the learned standing counsel of the said department. Taking into account, the petitioner is given the liberty to serve a copy of the writ petition, extra copy of the writ petition upon the standing counsel of the Animal Husbandry and Veterinary Department. The issue involved herein is that the petitioner, along with 11 others,
Yes, my lord.
along with 10 others,
10 others.
could not be accommodated due to want of vacancy, as is reflected in the minutes of the state level committee held on 13/9/2022. It is the specific case of the petitioner that on 25/3/2022, 23 or 22,
25. 25.
25/3/2022, the state, on the other hand, had issued an advertisement for in respect to tentative 13,300 vacancies. It is the specific case of the petitioner that as the vacancies were there, the question of the petitioner being not accommodated could not have been done so by the state level committee in its minutes dated 13/9/2022. This court, the learned counsel appearing on behalf of the respondent, more particularly the respondent number 1,
My lord.
shall apprise this court on the next occasion as to whether the petitioner were duly considered against the vacancies reserved for compassionate appointments.
My lord. Obliged.
Item number 3, 5, and 6 same.
Same animal husbandry.
It's same. 3, 5, and 6. I am obliged.
3, 5, and 6. Obliged.
Yes, madam, take this.
My lord.
Enough for
May I please your lordship. Petitioner's case for compassionate appointment that was rejected by the SFC or lordship will find at least.
Compassionate appointment.
Yes. Appointment
Rejected.
That is rejected by the SFC
Why?
on the ground of less than 3 years the balance of service.
Huh?
The less than 3 years balance of service on that ground. And in
I passed the judgment.
yes, I have annexed here. Lord.
Okay.
Lordship will find your lordship judgment.
Oh.
Uh,
Any appeal?
it starts from
Yes, madam.
Appeal has not.
Huh? They've accepted it. Order was passed some time back.
yes, my lord. At page 40,
31, 2023.
yes, my lord. Lordship, my prayer before your lordship is to my matter. This writ petition is clearly covered by this judgment, your lordship. That may be disposed of in the similar line.
You are how many?
Only one petition.
Where is your name? Rejected.
Lordship will find
16, 8, 2022.
Yes, page 37.
Page
Page 37 of my writ petition.
37.
Yes, ma'am. An extra right.
Less than 3 years.
That is the
So
time.
you want this set aside?
Yes, ma'am.
You set aside, madam. No point keeping in notice in here.
No.
At the end of the term, this is heard, Mr.
Deborah.
Deborah, the learned counsel appearing on behalf of the petitioner. Miss S. Burua appears on behalf of the respondent number 1, 2.
2 and 3.
Huh?
2 and 3.
What? Home? Who appeared?
Oh, yes, I am Kenneth.
Yes, you are there. 1, 2, and 3. Anybody from the PWD? No PWD. Mr. Ardor, did you see anywhere? Yes, madam. Did you see Ardor anywhere in the corridors out there? You have seen it? So we put his name. Mr. Ardor appears on behalf of the respondent number 4. The instant writ petition is taken up for disposal at the motion stage. Inasmuch as the issue involved herein has been already adjudicated upon by this court in its judgment and order dated 31/2023 in the case of Bhaskar Kaur versus State of Assam and 4 others. Is it reported? Not reported. Okay, so pass score 4. Ah, okay. Reported in 2023 SCC Online GAU 1321, wherein this court had held that the clause 1 of the office memorandum dated 1/6/2015, whereby the dependent family members of government officials who die in harness having less than minimum of 3 years of service being not eligible as per the office memorandum is unconstitutional, being violative of Article 14, and accordingly the same was struck down to that extent. Full stop. Next. It is the case of the petitioner herein that that the claim of the petitioner for compassionate appointment upon the death of his father was rejected by the state level committee in its meeting held on 16/8/2022 on the ground of having less than, on the ground that his father had less than 3 years balance service at the time of the death. Taking into account that the said that clause 1 of the office memorandum as indicated, office memorandum dated 1/6/2015 as indicated herein above, have already been struck down to be unconstitutional, being violative of Article 14 of the Constitution. This court therefore disposes of this instant petition, thereby directing the state level committee to reconsider the case of the petitioner by keeping in mind the object behind the scheme for compassionate appointment, the provisions of the office memorandum dated 1/6/2015, including the 10 principles as set out in the said office memorandum. This court further directs that the said exercise be carried out without insisting upon the compliance to clause 1 of the office memorandum dated 1/6/2015, and in the next state level committee meeting, which follows after a certified copy of the judgment is served upon the concerned departmental head as well as the chairman of the state level committee. The petitioner is directed to do the needful within 30 days from today.
Next.
7.
Please, Your Lordship. Your Lordship, my senior is on election.
Who is your senior?
Okay.
Yes, tell me. You want it some other day?
No, Your Lordship, for kindly pass over the matter for timing.
Huh?
Timing.
What is your prayer?
Your Lordship, the petitioner is an ACS officer, Your Lordship, and she was placed under suspension. And reason was that we have misbehaved with the foreign delegates. We have misbehaved with the foreign delegates. That was the
Foreign delegates.
Yes, Your Lordship.
Then?
There was a departmental proceeding was initiated against her, Your Lordship, and the person who was conducting her departmental proceeding, she has been replaced with a new inquiry officer.
Then?
So, Your Lordship, we are praying for that the new departmental proceeding must be on stay, Your Lordship.
You have not got the subsistence allowance?
No, Your Lordship, we have not got the subsistence allowance, sir.
That is one of the pair.
Pending disposal area, pay the operation of the impugn order dated 4/4 and direct year. What is this 4/4 business? Where is that 4/4?
For Your Lordship, when the new inquiry officer was replaced by the old inquiry officer, Your
Whereas
Lordship.
Vinita Pegu ISA was appointed as the inquiry to hold the inquiry into the charges against Barbie Hazarika. Whereas Vishnu is of opinion that they have not progressed much and exceeded the timeline. Whereas the charge officer is under suspension for long period of 9 months and
Srimati Vinita Pegu was the earlier state inquiry officer, Your Lordship, but she has been replaced by Sri Jadhav Saikya.
Now, why do you want that inquiry officer? You're fond of her.
No, Your Lordship.
Then?
The departmental proceeding was going on. The reason they have changed the
Yes, it has taken a long time.
is that they have taken time. But the thing is, Your Lordship, that when the new inquiry officer will be replaced by the old officer, then it will take the same amount of time, Your Lordship, because
Why?
they have to start the conduct afresh, Your Lordship.
Why? Can't they take into account those which have already gone?
That is the notice, Your Lordship, that they will start the we have got the instruction that they will take the department proceeding from afresh.
How's it? Isn't it taken from the point it has been done till by the earlier inquiry officer?
That can
Just
be,
for example, the recording of evidence. It can
That
very well
is-
be taken into account what he has done it.
yes, Your Lordship, that can be done.
Then what
They have
remains
the-
thereafter?
What we have got the instruction that
It is only the passing of the order.
we just need a
What is the stage of the inquiry?
stage of the inquiry is, Lordship, that they have conducted all the they have recorded all the evidence. They have taken all the witnesses.
So evidence has been recorded.
Evidence has been recorded, and they have taken the evidence from the witnesses also. But the thing is, they are not proceeding, and they are not giving the next date for the hearing.
Who is not giving? The earlier inquiry
Earlier
officer.
inquiry.
That is why they have
That's why
rightly
they
done
have
so.
changed replaced the they have appointed Mr. Jadhav Saikya. But the thing is, Your Lordship, that he will now take that same amount of time that she took.
Why?
Because we have got an instruction, Your Lordship, that he will take the same amount of time.
Why?
He will conduct the
No. If the evidence has been, your evidence you have given.
yes, Your Lordship,
So only it is the question of hearing.
hearing, Your Lordship.
Then why not the earlier inquiry officer
But
finish
they
it
will
off?
conduct the, they will
Yes,
conduct
Mr.
the-
Chuti.
Yes, Lordship, kindly see
When
page
do you want
15.
to finish it?
This is not a de novo inquiry, my lord. Lordship, kindly see page 59. This order, 4/4/2023. The last portion, my lord, whereby the appointees Jadhav Saikya, IS Secretary to Governor of
Is where is basis.
Yes, as
Yes.
is where is.
No, that is what I have
It
understood.
is not a de
But
novo.
when are you going to finish it?
My lord, I will have to take a instruction when time is given to the, my lord, 6 weeks.
6 weeks?
6 weeks, yes. Appeal, today appeal is, my lord,
I'll
appeal
submit the inquiry
Yes.
report within 6 weeks.
maybe
So
complete 6
4th of April.
It is
Yes, Mr. Chaudhary.
Sorry, my lord, I was
Yes, why do you want the challenging the inquiry officer?
My
business?
lord, in this manner, my lord, inquiry officer cannot be changed.
Why?
The Supreme Court judgment is there, my lord.
What does it say?
It says, my lord, merely because the report is not to the liking of the disciplinary authority, they can't change it, my lord.
No, there is no report.
So there is a report.
Where is the report?
No, kindly have
No,
a look
they
at
are
it.
changing it because the earlier inquiry officer was not doing anything. And you have been suspended for such a long time.
No, my lord, that is another aspect.
Yes.
Please come to the impugn order.
Now, page 59.
Yes, my lord.
Yeah.
Yes. I'm reading from the third subpara.
Hmm.
Whereas disciplinary authority is of the opinion that the disciplinary proceeding has not progressed much and exceeded the timelines for completion of the disciplinary proceeding, and it is necessary to appoint another inquiry officer to hold the inquiry in an expeditious manner.
Mr. Chaudhary, I'll take your matter next. Let me take up some other. Take your breath.
No, it's okay. I can
No, you take your breath. Just take your breath. I'll take the name next matter
Okay.
and then I'll take yours. Yes, next motion. 8. Yes, madam.
May I take your lordship? We had a petitioner who was working as a helper in a Anganwadi center, my lord. And thereafter one advertisement was issued, my lord, in the year of 2020-21, and she has submitted all her form for the post of helper with all relevant documents. But in the advertisement, there is one essential criteria as written here that 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 is criteria is there. The
Cannot be issued
18
to setting a certain
according
cost
to the
of
government rule,
select
the
list issued
candidate
by
will
the
be
Imam
selected
Welfare
only on
Select
oral
Details
interview,
on
my
the Senate Part
that was
1
47. But
without
no
following
interview was
eligibility
initiated.
criteria advertisement well to avail. So you are challenging some
Yes,
advertisement.
Advertisement not select list, my lord.
You are
Select list.
challenging which select list?
Select
Page
list, my lord. Type copy is 56, my lord.
56.
Annexure 13. But in the
Yes.
select list, the no date
You are
was
concerned with which one? Anganwadi Center.
12, my lord.
12.
12. The
2 number Dimu Jubok Sangha.
Sangha,
AWC, Mrinalini Dhaka.
but
First.
she is the president of the
You are
select-
you are second
No, I'm
or
the
you are
second.
not selected at all?
Not selected.
Why?
The person who selected the respondent number 6.
Understood. Why you have not been
She
selected?
is the president of that Anganwadi center, and
Who?
the who has already been selected, and her term will be expire on July 2020.
Who? Mrinalini Dhaka?
Yes, my lord.
She is the
President of the managing committee of the Anganwadi center, my lord. And her term will be expire on July 2023. But surprisingly, she submitted her resignation without submitting her resignation before the committee, and she applied for the post, and somehow he managed to manage the authority and selected. And earlier, she herself filed a representation before the authority to appoint the petitioner, as he was working from last 2014, my lord. So my prayer is that though she is the holding the post of president,
president of what?
president of
Let us see the advertisement. Does it debar a president?
there is no such
Page 46.
Page
46.
case for
46. The female candidate who applied for the post should be local. So she is local.
yes,
Age of the heir should be 18 to 44 years. She falls within it. The qualification for Anganwadi should be HS pass. She has passed.
yes,
Also annex the mark 6 so and so. The candidate should be, helper should be HSLC. She is HSLC.
yes, my lord.
Should furnish the permanent residence as a certificate, so she has that.
Yes,
Selection should be based on according to the percentage obtained in HSLC. Is it yours is more or less?
SSLC pass.
Her is more or less? More.
More.
Where is the offending thing?
But accordingly, 18, my lord.
Huh?
According to the government rule, the candidate will be selected only on oral interview. No interview was initiated.
No?
No interview was initiated by the respondent authority. The petitioner did not call for interview, my lord, and suddenly published the select list. But the date was
Now tell me, in pursuant to this advertisement, did you fill up your form?
yes, my lord.
How do you show that?
But I have annexed, my lord.
Application, page 53.
Yes, my lord.
Okay, then
Then thereafter she waited for interview, my lord, but she did not call for interview, and suddenly in the month of March, my lord, the select list was published, and where the respondent number 6 was selected. And
is this the select list, annexure 13?
yes, my lord, annexure 13.
So you have numbered it so 13.
Not a complete.
Serial
Complete
number
one.
12.
Chalo, will issue notice. You find it out.
Yes, this is the
Her only allegation is, as I could find out, is that there was no interview
Yes, my lord.
which was required.
No, interview is not required, my lord. As per notification, there shall be no individual marks for the members facility for the honorable warden and helper. The individual marks is there only on the basis of SSLC pass numbers. They will make an cooperative statement, and amongst them, who are to the merit ballot, he will be selected.
But interview
That is the procedure. Interview means they on that day that is fixed. They will come and show their original mark sheet.
But then also there is, you
There is no
mention it
individual
out
mark.
there.
So individual marks is given. Notification.
Heard
So-
Mrs. A. Buzarburwa, the learned counsel appearing on behalf of the petitioner. Mr. T. Susuti appears on behalf of the respondent number 1, 2, 3, 4, 5. You should notice making it returnable on how long?
Fifth step.
We'll have it on 12th of June.
Yes.
You should notice making it returnable on 12th of June 2023. As the respondent number 1 to 5 is duly represented by Mr. T. Susuti, extra copies of the writ petition be served upon him by 10th of May. Full stop. In respect to the respondent number 6, steps be taken by way of registered as well as usual by 10th of May. The case of the petitioner herein is that pursuant to an advertisement dated 29/12/2021, the petitioner also filed her application. But the respondent authorities, without calling for any oral interview, which is required in terms with clause 18 of the said advertisement, had selected the respondent number 6 by the select list dated
no date was mentioned. Madam.
by the select list encloses annexure 13 to the writ petition. The learned counsel appearing on behalf of the respondent number 1 to 5 shall obtain necessary instructions in that regard as to whether the selections so made, whether there was any select list as have been enclosed as annexure 13 to the writ petition, and if so, whether the respondent number 6 was duly selected. Further to that, the learned counsel for the respondent number 1 to 5 shall also apprise this court as to whether there was compliance to the requirement of the advertisement dated 29/12/2021. Yes, Mr. Chaudhary.
Madam, our submission is like this, madam. Once an inquiry is start, the inquiry officers cannot be changed in the manner as is sought to be done. Why I'm saying so, my lord? There is a judgment on Rule 15 of CCA rule, which is akin to Rule 9 of Art. If you also to kindly have the judgment, my lord. 1971.
Got a copy of it?
I'll give the copy. Only one paragraph.
You give it to me. I'll just find it out.
1971 to SCC 102.
See? 102.
102 and Lordship may kindly come to page 105, para 12. Has the Lordship's got it? Yes.
Constitution bench.
No, here there. Yes. Yes, my. Para 12. It seems to us that Rule 15 on the face of it.
Just 1 minute.
I'm
Our
sorry.
internet is still slow. Yes. Para?
Para 12, madam. at page 105,
Yes.
it seems to us that Rule 15 on the face of it really provides for one inquiry. But it may be possible if in a particular case there has been no proper inquiry because some serious defect has crept into the inquiry or some important witnesses were not available at the time of inquiry or were not examined for some other reason, the disciplinary authority may ask inquiry officer to record further evidence. But there is no provision in Rule 15 for completely setting aside previous inquiries on the ground that report of the inquiry officer or the officer does not appeal to the disciplinary authority. Disciplinary authority has enough powers to reconsider the evidence itself and come to its own conclusion on the Rule 9. Well, my humble understanding of this passage is Rule 9 also, similarly as Rule 15, it contemplates one impact. If disciplinary authority notices any minor shortcoming in the conduct of the inquiry, then my lord, disciplinary authority is competent enough to direct the inquiry officer to do the inquiry in the manner as the disciplinary authority desires. But in my humble submission, my lord, perhaps there is no provision of my lord completely ousting the earlier inquiry and
No. They are not ousting the earlier inquiry. The earlier inquiry is going to be there. It is only that inquiry officer is not doing it. That is why they are asking somebody else to take.
No, my lord. Kindly see, that means they are going to change the inquiry officer.
That is the only thing. They are not doing anything else. All evidence, everything has been duly recorded. It is something similar, like in a civil suit like that. If a particular person concerned is given all evidence, then also at the last moment,
I'm not saying, my lord, I can appreciate a particular judge is in a particular station. Supposing until the stage of evidence he was there, therefore this successor will come and take over the. I'm not on that one. Here, my lord, it's a question of changing an inquiry officer because, in the opinion of the disciplinary authority, the inquiry is not being directed in a proper manner.
No, that is not the reason why. It has been mentioned that there is tardiness on the part of the inquiry officer in completing within the time frame.
So, my lord, the same 6 weeks times can be given to him.
So why is it necessary? It can be very well be completed by the whoever inquiry officer it is. Let her be complete it.
In case of a quasi-judicial proceeding or a judicial proceeding, an administrative inquiry like this, there are a lot of difference. Here, my lord, a particular inquiry officer has proceeded in a particular. If it is on account of delay, it is I am who am suffering, my lord. How government is suffering?
Understood, but what is your do you have a
My humble
now? How can you have a grievance against this?
I have a
You
grievance.
should be that if you are suffering, the matter should end as early as possible.
My humble no, that is correct. As long as, my lord, if the speedy justice is required, that I cannot have any grievance. But the question is the grounds on which it is sought to be,
The
changed.
ground is specific that the
Can
earlier
you see,
inquiry
madam?
officer has taken more than 1 year,
Whereas
more than a
disciplinary
long
authority
period
the-
of more than 9 months.
It is the disciplinary authority has not progressed much and exceeded the timeline for completion of the disciplinary proceeding, and it is necessary to appoint another inquiry officer to hold the inquiry. Well, the reason may be okay, but the subsequent action they want to change it. Whether in view of this decision it is permissible.
No, but that decision doesn't say it. That decision only says that once you have an inquiry, you can set aside that inquiry. But here there is no setting aside. If you see the last line,
No, my lord.
the person concerned shall go ahead as is, where is basis. Meaning the whatever has already happened, that is happened. The only
From
the
the
thing
next
is
stage, from the no, my lord, what I am on is, if your lordship would kindly come to para 12 of the judgment,
yes, I've
or
seen.
once again,
Yeah.
it seems to us that Rule 15 on the face of it really provides for one inquiry.
Yes.
One inquiry.
Yeah.
But it may be possible if in a particular case there has been no proper inquiry because some serious defects has crept into the inquiry or some important witnesses were not available at the time of inquiry or were not examined for some other reason, the disciplinary authority may ask the inquiry officer to record further evidence. What I'm trying to submit from this passage is, my lord, Rule 15 envisages only one inquiry. If there is any shortcomings on the part of the inquiry officer, the disciplinary authority can direct him. Complete it
But
within-
are you saying that the disciplinary officer cannot change it?
No, my
No.
that
That's
is-
too
that is in my-
far-fetched.
No, my lord. I can
That's
appreciate
too far-fetched because of saying that the disciplinary authority doesn't have. Just tomorrow,
No, suppose,
inquiry, the person concerned has already left.
no, yes.
He had died. Then
That could be a
the
reason.
inquiry will come to an end.
Supposing there's an allegation of bias against the inquiry officer, then also it can be changed. Those are, my lord, exceptions are there. But, my lord, the manner, here what has happened? There's subjective satisfaction of the disciplinary authority that the inquiry has not progressed in the desired manner. So therefore, he is very much competent to say, all right, whatever had happened within 2 weeks, you complete the inquiry, or 3 weeks. Instead of doing that, is it open to him to change the inquiry officer? That's the point, my lord.
No, the inquiry officer has only recorded the evidence. The earlier inquiry officer has only recorded the evidence.
I'm not on that point. My question, my submission is, in this
But do you
situation-
have a right to insist that this inquiry should?
It's not a question of my right, my lord. Question is, my lord, in the manner, if I am prejudiced, then what happens? I may be, my lord, we do not know why disciplinary authority want to do this.
It has been made clear out here because he has taken more than 9 months.
My lord,
Exceed the
disciplinary
10 months.
proceeding, sometimes it happens.
Very
my lord.
difficult case, Mr. Saurabh.
No, my lord, my only, our.
I think you
case is
should
premised
limit
on this.
yourself that direction be given for payment of AR and completion of the department discipline proceeding within 6 weeks as directed out here.
So my humble submission is, my lord, I think the earlier inquiry officer can be directed to do the same thing.
That
I think
would-
disciplinary authority could
you
have
see,
directed.
then this court has to hold it.
Yeah.
That the earlier this order is wrong, which prima facie is not doesn't show anything, Mr. Chaudhary.
My lord will consider that aspect, my lord. My humble.
I would have understood if there is an inquiry done and thereafter there is a formation of an opinion by the inquiry officer, then something is being changed to do. But can you say that when the inquiry officer has not done so?
No, that's correct, my lord. I'm not saying that a view has been taken by particular that I've seen the order. But my only concern was whether one inquiry officer can be changed merely because he is delaying the progress.
Absolutely, why not? If it is not so, if can you say that the 9 months it's taken?
All
A
right.
person has been put under
What is the
suspension
what
for
is
the 9 months.
guarantee that the new inquiry officer will complete within 6
So
weeks,
there is
my lord?
already a thing. If you want, I can issue the direction to that effect that you have to complete in the as per the order dated 4/4. Your matter ends there.
No, my lord, my only humble submission is why the same direction cannot be issued to the earlier inquiry officer by the disciplinary.
But how can you first and foremost what is your right to insist on that?
Choosing the inquiry officer, my lord, I
My-
don't think already.
my-
You don't have a right to insist which inquiry officer should be.
No, my lord. No,
I would have
yes.
understood.
No, I'm not choosing.
No, I would have understood that it has been taken as if that the inquiry will start de novo. Then you are prejudiced. How can you be a prejudice out here when there is the inquiry officer has not spelled out that I have done this or that?
No, my lord, I leave it to lordships, but my only humble submission is I'm challenging the decision-making process. My entire case is premised on this passage of the report, where Rule 15 was interpreted, which is akin to Rule 9, which says it only contemplates one inquiry. Exception being in certain situations, if the disciplinary authority is of the view that things are not going in the manner they desire, then they can certainly issue certain direction. But you can't substitute that inquiry officer by anyone in a situation like this. Yes, I can appreciate the inquiry officer is no more, or he is, my lord, incapacitated on account of some infirmity, or then those are different situations. But in a
Well,
situation,
Mr. Chaudhary, what you are submitting for this court to accept would not, this court is not in a position to accept
No,
it.
no, it's
But
not,
no,
madam.
but I'm telling you, but you may have a case out there. So better off instead of issuing just notice out here and dismiss the petition so that you go there before the division and bench and then apprise, because this court is not. Because if I issue a notice without a stay, this is going to affect you.
Ah.
So better I dismiss it, giving, however,
no,
the subsistence allowance I'm dying
Yes, so that
to
can
be
be-
paid immediately.
no, I leave it to
Yeah,
lordships, my lord.
no, but if I don't give a stay,
Hmm.
this challenging this notification becomes useless.
My lord, may I like to examine this matter. My lord, maybe a short notice within 7 days. I have a feeling, my lord, maybe what I'm saying, there is
But I have to state.
for 7 days, nothing is going to happen. Next Monday, lordship can have this matter. Status quo as on to the lordship need not stay also. Let me find out, can I find out more materials on it? I have a feeling, my lord, this power is, something circumscribed.
No, my lord,
It's very difficult.
but changing, but that is, my lord, the reason has been given. This order does not speak about the prejudice of the petition. There is no prejudice. Only remaining work he will complete. meaning thereby he will complete it within time. The earlier inquiry officer did not do anything. They complete exceed 9 months. That's why, my lord, for justice, my lord, to finish all this within time, that is an inquiry officer being appointed. There is no bar at all. And I have distinguished this paragraph.
The
12
problem
of-
arises out here for this court to appreciate Mr. Chaudhary's submission is what prejudice is caused to her, to the petitioner. I don't see there is any prejudice
No, my lord.
caused.
He will complete the remaining portion of the inquiry. Already evidence recorded. The lordship may pass the order, my lord, mentioning all these things. That those who have already been done, that should be remain the same, and the remaining portion which is not
Why
done.
should I direct? It is already there.
Yes, not that. Otherwise,
And I think in all inquiry proceedings, if I'm not wrong, the person has to sign it also.
yes.
Yes.
For
Both-
this
both the-
signature.
Like the moment you are giving an office
Yes, yes.
memorandum of charge, she will file a statement of defense, and thereafter all the evidence which is being given,
Yes.
and cross and the proceedings while it is being done, it is put to the signature.
Every day proceeding will be signed by both sides.
Oh, that is already there, so you can't change it. And if there is a change out there, obviously you will get a good right for filing an appeal and whatever.
My
may
lord,
be.
4/4/2023,
I'll leave it to
But
Dr.
as
Malik.
someone,
6 weeks, my lord,
some
remaining
wise soul has stated that it is difficult, may be difficult to convince one person, but it may be easier to convince two.
only-
Sometimes it is said, my lord, what is just may not be legal. What is legal may not be just. And I leave it to Lord.
Yes. Third, Mr. Kane Chaudhary, the Learned Senior Counsel, assisted by Ms. Swanso, and Mr. T.C. Suti appears on behalf of the respondent numbers 1, 2, and 3. The instant writ petition has been taken up for disposal at the motion stage itself. The case of the petitioner herein is that the petitioner was suspended by an order dated 2/6/2022 by the Secretary to the Government of Assam Personnel A Department in exercise of the powers under Rule 6(1)A of the Assam Service Discipline and Appeal Rules 1964. Pursuant to the suspension of the petitioner, the respondent number 2 issued a show cause notice bearing number AAP.101/2022/23, dated 10/6/2022, thereby asking the petitioner to show cause as to why the penalties enumerated under Rule 7 of the Rules of 1964 should not be imposed upon her on the charges of misconduct, gross misconduct, insubordination, tarnishing the image of the state before foreign dignitaries, dereliction of duty, and violation of the provisions enumerated under Rule 3 of the Assam Civil Service (Conduct) Rules 1965. A period of 10 days was given to the petitioner to submit her written statement in defense from the date of receipt of the notice. It appears from the record that the petitioner had submitted the written statement for defense, and pursuant thereto, defense, thereby denying all the allegations leveled against the petitioner, and prayed that the petitioner be exonerated of all the charges framed against her, which was without any basis. Subsequent thereto, in exercise of the power under Rule 9(4) of the Assam Service Discipline and Appeal Rules 1964, for short, the Rules of 1964, by an order dated 2/9/2022, an inquiry officer was appointed. Further to that, in exercise of the powers under Rule 9(5) of the Rules of 1964, a presenting officer was also appointed. Thereupon, it appeared that it further appears from the records from a perusal of the writ petition that there has been the inquiry proceedings went ahead went ahead. Continue. And on 22/3/2023, the inquiry proceeding was fixed for cross-examination of the petitioner. Full stop. Subsequent thereto, on 24/3/2023, the responding authority, the disciplinary authority, had further extended the period of suspension of the petitioner by another 3 months with effect from 2/3/2023 or until further orders. It has been further mentioned in the writ petition that the inquiry officer, by the communication dated 30/3/2023, summoned the remaining prosecution witness in the matter for hearing and recording their evidence on 4/4/2023 at 11 a.m. Mr. Chaudhary, one thing I don't understand,
Yes, my lord.
on 22/3/2023,
Yes.
how can there could be the cross-examination of the petitioner prior to that?
First, my lord, they have to complete their evidence.
Yes. So how this is being
This
done?
is wrong, my lord.
So that is what the inquiry officer was wrong here also. Anyway.
Sometimes, my lord, we keep mum during the course of the inquiry so that we can develop the
Anyway.
case later.
Subsequent thereto, on 4/4/2023, when the case was fixed for recording of the evidence of the prosecution witness, the Secretary to the Government of Assam Personnel A Department issued an order dated 4/4/2023, whereby, in exercise of the powers under Rule 9(4) of the Rules of 1964, the earlier the inquiry officer, on the ground that there has been a delay in completing the disciplinary proceedings, appointed a fresh inquiry officer, one Sri Jadab Soikia, to inquire into the charges against the petitioner, as is where is basis of the proceedings. And the new inquiry officer was directed to submit the inquiry report within a period of 6 weeks. The petitioner is being aggrieved by the order dated 4/4/2023, whereby the inquiry officer was changed. It is also the grievance of the petitioner that although the petitioner has been suspended on 2/6/2022, 2/6, no?
Yes.
2/6/2022, but the petitioner have not received the subsistence have not been given the subsistence allowance since the date of her suspension. Although it is the mandate of FR 53 of the FRNSR as applicable to the state of Assam, that the petitioner is entitled to the subsistence allowance in accordance with the said provision. I've heard the learned counsels for the parties and have also perused the materials on record. Let this court first take into consideration the issue as to whether the petitioner is entitled to the subsistence allowance from 2/6/2022. The fact that the petitioner has been suspended and there is a disciplinary proceedings going on is an admitted fact, as could be seen from the order dated 4/4/2023, from the orders dated 2/6/2022, as well as 4/4/2023. The petitioner, in terms with FR 53 of the FR and FSR as applicable to the state of Assam, is entitled to the subsistence allowance. Denial of the said subsistence allowance would render the action of the respondent authorities, denial of the said subsistence allowance would be contrary to Rule 50 FR 53. In that view of the matter, this court therefore directs the respondent authorities, and more particularly Mr. Sutia, which one?
Other controlling authority is the personnel department, and
To the respondent number 2,
Yes, one minute.
1 or 2? Additional
One.
chief secretary or the secretary?
Additional Chief Secretary Dr. Personnel Department. 1 and 2, Lordship.
Direct the respondent number 1 and 2 to forthwith pay the subsistence allowance to the petitioner for the period from 2/6/2022 till the petitioner till the completion of the
Department.
departmental proceedings or the reinstatement of the petitioner, whichever is earlier. The said exercise be completed within a period of how much? 2 weeks? 2 weeks.
Yes, that can be.
From the date a certified copy of the instant order is served upon the respondent number 1. Number 2. The next question, therefore, which arises as to whether the petitioner, whether the exercise of power under Rule 9(4) to change the inquiry officer in the midst of an inquiry proceeding is permissible. It appears from a perusal of the writ petition itself that the petitioner was put under suspension on 2/6/2022. Upon furnishing of, pursuant to that, the departmental proceedings was initiated by the issuance of the show cause notice on 10/6/2022. It further appears that on 12/7/2022, the petitioner has already replied to the show cause notice, denying all the allegations leveled against her. Thereupon, on 2/9/2022, the inquiry officer was appointed in exercise of the powers under Rule 9(4) of the Rules of 1964. A perusal of the communication dated 33/2023 issued by the State Inquiry Officer Assam reveals that 4/4/2023 was fixed for recording of the prosecution evidence. The above would therefore show that almost 6 months have gone by. But till date, no prosecution evidence have yet been recorded. Now, the prosecution, the stage of recording of the prosecution witness is yet to be over. It is under such circumstances the impugned order dated 4/4/2023 was issued, whereby taking into account the delay in completion of the inquiry proceedings, the respondent number 2 have changed the inquiry officer and reappointed and appointed one Sri Jadov Deka to proceed with the inquiry as is where is basis of the proceedings, and with a further mandate that the said inquiry officer shall submit the inquiry report within a period of 6 weeks without fail.
Jadov Soikia, not Deka.
Jadov Soikia. Mr. Tain Chaudhary, the learned senior counsel, while challenging the communication, the order dated 4/4/2023 has drawn the attention of this court to a judgment of the Constitution Bench in the case of K.R. Dev versus the Collector of Central Excise Shillong, reported in 1971 to SCC 102. Referring to paragraph number 12 of the said judgment, the learned senior counsel submitted that it is not permissible in terms with Rule 9(4) to change the inquiry officer if the inquiry officer is to the disliking of the authority. Paragraph 12 of the said judgment, to which the reference has been made being pertinent, is quoted here in below. Next. A perusal of the above quoted paragraph would reveal that there is a reference to Rule 15 of the classification and control rules, which is parameter to Rule 9(1) of the rules of 1964. It further reveals that from the said paragraph that Rule 15 of the classification and control rules envisages for one inquiry, but it has been further observed that it is possible in a particular case where there was no proper inquiry because of some serious defects, the disciplinary officer may ask the inquiry officer to record further evidence. It was observed that there is no provision in Rule 15 for completely setting aside the previous inquiry on the ground that the report of the inquiry officer or the officers does not appeal to the disciplinary authority. It was further observed by the Supreme Court that the disciplinary authority had enough power to reconsider the evidence itself and come to its own conclusion under Rule 9. Next. A perusal of the above paragraph, however, in the opinion of this court, cannot be applied to the facts of the instant case. Inasmuch as the inquiry so held by the earlier inquiry officer was at a nascent stage where the evidence of the prosecution, the evidence of the department was yet to be completed, as could be seen from paragraph, the order dated, the communication dated 30/3/2023. Therefore, the question of setting aside the inquiry further does not arise, taking into account that the new inquiry officer has been directed to proceed on as is, where is basis of the proceedings. Further to that, the new inquiry officer, having been directed to complete the inquiry within a period of 6 weeks without fail, this court finds no reason for interfering with the order dated 4/4/2023. Consequently, the instant writ petition stands disposed of with the following observations and directions. First, number one, the order dated 4/4/2023 is in accordance with the provisions of Rule 9(4) of the Rules of 1964 and calls for no interference. Number two, the petitioner is entitled to the subsistence allowance from the date of her suspension dated 2/6/2022. And accordingly, the respondent number 1 and 2 are directed to forthwith disburse/release the subsistence allowance to the petitioner. If already the said amount have not been paid. The said disbursal/release of the subsistence allowance for the period from 2/6/2022 till the date of completion of the departmental proceedings or reinstatement of the petitioner, whichever is earlier, be done within a period of 2 weeks. The said payment of the subsistence allowance from the date of the suspension dated 2/6/2022 till date be paid within a period of 2 weeks from the date a certified copy of the instant order is passed. It is served upon the respondent number 2. Further to that, till the completion of the departmental proceedings or reinstatement of the petitioner, whichever is earlier, the respondent authorities shall continue to pay the subsistence allowance in terms with FR 53. With the above the petitions. Yes.
Obliged, my lord. We have,
What are you challenging?
My lord, I have no file, my lord. He has requested me over mobile phone.
My lord, the case of the petitioner is that as per the interview dated 3/10/2018, he was selected, but no appointment was done till today. It is his case.
Why?
Their instruction.
Okay, we issue notice and ask them why they have not done it.
My lord,
But Mr.
Kamesh Talukar, my lord.
M.H. Talukdar, the learned counsel appearing on behalf of the petitioner. Miss
MD was
Mr. S. Dutta appears for respondent number 1. Ms. M.D. Bora appears for respondent number 2, 3, and 4.
my lord.
Issue notice making it returnable by 31st of May 2023. As the respondents are duly represented, extra copies of the writ petition be served upon them by 10th of May. The issue involved in the instant writ petition is that the petitioner pursuant to a selection process was selected as the Sarkari Gambura. However, the petitioner has not been appointed, given the order of appointment being aggrieved. The petitioner is before this court. The learned counsel appearing on behalf of the respondent, number 2, 3, and 4, shall apprise this court on the next returnable date as to why the appointment order has not been issued in favor of the petitioner.
No, bless my lord.
Number 10.
May please, Your Lord.
Hmm.
The case of completion appointment or
Compassionate?
appointment.
Yes.
Her husband died in Los in the year 2007.
During service career?
Lordship.
Okay. Then
Then Lordship immediately after his death, demises
2007.
Yes.
Then
We submitted our application Lordship.
Then
Thereafter Lordship, as per your information Lordship, in Forest Department since 1992, no appointment was made Lordship on completion ground due to ban imposed by the government. Accordingly, Lordship, all applications since 1992 were kept pending Lordship, and altogether it was considered in the year 2015. So prior to that Lordship, in 2011 also Lordship, an SLC was held, and in that SLC Lordship, this candidature of this petition has been wrongly rejected Lordship, in the grounds that it was submitted.
what was the age of your husband when he died? He died today, now 16 years back.
Yes.
Then
Exact that was I can't say right now, but that is not. But it was in time during his service Lordship he died. During his service Lordship he died.
understood. But is this a case for at all issuing a notice because of the fact that in the year 2007 your husband died?
Right, yes.
Compassionate appointment is for the purpose of tiding out the difficulties immediately.
I appreciate that. Thing is,
And after 16 years, you are fighting and you have not been able to. How are you surviving for the last 16 years?
last 16 years was surviving on the Lordship, he is getting some major amount of Lordship pension.
Ah,
And that is there. But Lordship, thing is that Lordship, since it was because of the delay caused by the respondent itself Lordship,
why? Why do you say so?
because Lordship, there was some ban imposed by the government to appoint and compensation cover in Forest Department. So Lordship, all applications since 1992 were kept pending, and altogether it was 2015
It was 2015.
Oh, Forest Department.
Yes, sir.
Yes.
That
I
is the
remember.
ground order.
Where is the Forest Department? Heard Mr.
J.
J. Kolita,
Sir.
the learned counsel appearing on behalf of the petition. None appears on behalf of the Forest Department on call. The learned counsel for the petitioner submitted that at the time of filing the writ petition, a copy of the writ petition was duly served upon the standing counsel of the Forest Department,
Your name of the
and their names have been duly shown in the cause list. Issue notice making it returnable on 12th of June 2023. The learned counsel appearing on behalf of the petitioner submits that he may be permitted to serve extra copies of the writ petition upon the standing counsel of the Forest Department. He is permitted to do so by 10th of May 2023. The case of the petitioner herein is that the petitioner's husband expired in the year 2007, and thereupon the petitioner immediately applied for appointment on compassionate grounds. However, till date, on account of the fault of the respondent authorities, the petitioner have not been given the appointment order, given any compassionate appointment. It is further the submission of the petitioner that the learned counsel for the petitioner that it is difficult for the petitioner to survive without without an appointment, and her family members are suffering in view of the death of the husband of the petition. The respondent for the Forest Department shall on the returnable date apprise this court as to why the petitioner's case has not been considered for the purpose of compassionate appointment till date.
outline.
But to kindly adjourn the matter for today.
What?
Kindly adjourn the matter for today.
For the day. Why?
Some medical emergency.
Hmm?
My sister has some medical.
Yes. Respondent, what is their case?
Lordship,
Equal pay.
yes, Lordship, petitioner contractual employee, Lordship,
They are asking for equal pay with
regular employee.
the benefit of equal pay for equal work, revision of wages, extend facilities of so and so, grant of minimum wages of equal pay, paid holidays, and so and so. We should notice, man. The interim which you are asking for, that cannot be granted. Now, for the present. Yes, your name? Oh. We do one thing. Why? How much court fee you have paid? Heard Miss
D Deca.
P. Deca.
D.
D. Deca, the learned counsel appearing on behalf of the petitioner. Miss, madam, you are appearing for?
Ardeka for respond number 2, 3, 4, and 5.
So and so appears for respond number 2, 3, 4, and 5.
For respond number 10. M. Smith for respond number
Transfer appears for respondent number 10. Who appears for 1? You. Ms. Esburwa appears for respondent number 1, 6, 7, 8, and 9. Issue notice making it returnable by 19th of June 2023. As the respondents are duly represented by the respective councils, extra copies of the writ petition be served upon them by 12th of May 2023. The case of the petitioners herein is that the petitioners are entitled to parity, pay parity, as well as other facilities to which a normal employee, a regular employee under the respondent number 2 is being afforded. The respondent are directed to file their affidavits in the incident matter by 12th of June 2023. The petitioner, if so advised, would be at liberty to file their reply by the next date fixed. Well,
Please, Your Lordship. Lordship, matter pertaining to appointment of completion process. Petitioner's case has been considered and recommended on my lord 10/10/2022. That is on page 27.
then
Thereafter, Lordship, it has not been placed before the SLC matter.
it has not been placed by before the SLC.
My lord.
Very well. Who has recommended?
And the DLC matter.
By the DLC. Yes, your name?
S. Sutia matter.
Miss M.
lord.
Sutia, the learned
Lordship.
counsel appearing on behalf of the petition.
My lord, Lordship, I kindly have a look, page 28 for a moment, my lord.
28, yes.
The
Serial number 8, my lord. Petitioner name.
serial number
Serial number
8,
8, my lord.
Prayer number
8, my
Serial
lord.
of?
Page 23 of Lordship, page 28 at serial number 8. The name of the petitioner reflected, my lord.
Hmm,
And then
accepted.
Then the Lordship may I read, my lord,
Hmm,
the consideration. The earlier proposal was placed before the DLC meeting held on 21/5/2009 and rejected due to the non-availability of 5% reservation post of grade 4 under compassionate ground. Hence, the matter may be forwarded to the government after receiving of vacancy position of the grade 4 post submitted by the superintendent of excise Mongoldoy for appointment of compassionate term. And the direction to the department to submit the vacancy position. Now, they have to, there is no present excise department.
My lord, it was then after receiving the vacancy position
Yes.
from the department, my lord. They have already submitted it.
If there is vacancy, then his name may be forwarded to the,
this is there, na? 28/10/2022,
My lord, my
page 30, isn't it?
yes.
page 28, my
No, page 28 is that, but page 30,
my lord,
vacancy position.
my lord.
Miss Sutia, the learned counsel appearing on behalf of the petitioner. None appears on behalf of the excise department on call. Miss M. Deborah appears on behalf of the respondent number 2,
2 and 4, my
4,
lord.
2 and 4.
My lord.
To issue notice making it returnable by 7th of June 2023. The learned counsel for the petitioner submits that before filing the writ petition, the petitioner had duly submitted the copy of the writ petition was served upon the standing counsel of the finance of the excise department. In the cause list, their name has been shown,
Effect might
and also in the cause list, the name of the Standing Council Excise Department has also been shown. Taking in note of that, this court further gives the liberty to the petitioner to serve extra copies of the writ petition upon the Standing Council of the Excise Department in respect to the respondent number 1, 3, and 5. Ms. M. Deborah, as regards the respondent number 2 and 4, extra copies of the writ petition be served upon Ms. M. Deborah by 10th of May. The case of the petitioner herein is that the petitioner was recommended by the district level committee for appointment on compassionate grounds in its meeting dated 10/10/2022. It is the further case of the petitioner that although the case was to be forwarded to the government after receiving the vacancy position of grade 4 submitted by the Superintendent of Excise, Mongoldoy, for appointment on compassionate grounds. But it is the case of the petitioner that on 28/10/2022, the Superintendent of Excise, Mongoldoy, had duly submitted the vacancy position, wherein it shows that there is a vacant grade 4 post. The learned counsel appearing on behalf of the respondent shall apprise the court on the next returnable date. Now, it is, however, the case of the petitioner that in spite of that, the authorities concerned have not placed the matter before the state level committee for appointment on compassionate grounds. The learned counsel appearing on behalf of the respondent number 2 and 4 shall apprise this court on the next returnable date as to whether the case of the petitioner has been placed before the state level committee.
Lordship, may I submit one thing, my lord?
Please do.
Lordship, the page 30, my lord, this is the only vacancy position. This is not written here. This is the vacancy for the compassionate appointment. Only one post is vacant. If only one post is
She
vacant,
says so. You find out.
my lord,
We'll find it out next
my lord.
when the
May I
matter
please
comes.
Deeply obliged, my lord.
My lord, may I pray till then, my lord, one post may be kept vacant, my
Huh?
lord. One post may be kept vacant.
One
Next-
post to be kept vacant. That is impossible.
I am deeply obliged, my lord.
13.
Obliged.
Yes. Yes, Mr. Shah.
If I'm saying that this matter will pass over for the date,
Passed over for the day. Fantastic. Why so?
my senior Mr. You can
Even without the council, I am issuing notice. Then also you are saying so? Suppose as to why the list of 492 transfers should not be modified because consider which department? APDCL. Oh. Okay. At the request of Mr. MP Sharma, the matter stands adjourned for 4 weeks. When?
in the next week.
Why?
But the deputy senior has got some difficulty today, lot of it, so I pray for accommodation for him.
To be listed on 17th of May.
Like
14.
Please, the lordship. My lord, the petitioner with the lordship is an employee in the scale 3 officer of Assam Gramin Vikas Bank. Is aggrieved by the denial of promotion to the next higher post, that is scale 4. Lordship may come to
page 16, this is the circular by which application.
Yes, you are referring to?
Page 16, my lord.
Yes.
Lordship will see this is the circular by which applications were sought for from scale 3 officers for promotion to scale 4. My lord will see that at serial number 2, number of vacancies is 11. Then the eligibility criteria is 4 years of service in scale 3 to be reckoned on, my lord, 1st of April 2003. So anyone who is eligible on 1st of April 2023, they will be eligible. And my lord, at serial number 7, list of successful candidates for promotion shall be made by the committee in order of merit on the basis of combined marks of interview and performance appraisal report. The number of selected candidates to be empaneled for promotion shall be equal to the number of notified vacancy in the order.
So it will be 11.
Yes. Now, ultimately, they promoted 5 persons. And all the 5 persons are junior to me. I was not promoted. My lord.
But it is based upon two things. One is
Yes.
interview and one is performance appraisal report.
Yes, my lord.
Then
Now, my lord, there is no specified cutoff mark that indicating that this is the mark, anyone getting below that will not be considered. So, my lord, I must know the reason why I am deprived, my lord. To my knowledge, my lord, I was not given the promotion because I don't have much time before retirement. I am going to retire on 30th of June this year. This is precisely what was asked to me by the chairman in the interview. How many days of service you are having at this moment?
so your case is that if you are given a promotion, then and as you are going to retire, unnecessary burdening the bank it will. That is their case.
We do not know. But one thing, my lord.
So you don't know means that case is not that.
May not be, my lord. I may know. I might be denied promotion for some other reason.
So denied promotion for some other reason, not the reason for that. That as you are going to retire on 36 2022 or 23, that is not one of the grounds.
No, that is one of the ground.
Then you are saying just now that is the ground.
That is the ground. But I was not given.
You have taken an apprehension has come to your mind because of that question being put.
Yes. But what is the reason for not filling up the 11 vacancies, my lord? It is not a case that they do not have the vacancies. They have notified 11 vacancies and they have not given any cutoff mark. So what is the good reason for not filling up? Definitely, if I am found not suitable, then there must be some reason. To my knowledge, my lord.
What is this? Seniority list?
Yes, my lord. Seniority list is the list.
But seniority has nothing to do.
No, my lord. Why I am saying there is a rule in there is a promotion rule. It says that in spite of the interest.
What is your name?
My lord.
Joyanto Kumar Dev.
Yes, my lord.
Where is he?
He is placed as serial number 31 in the seniority list.
Seniority list. You are number 4 in the name of the interview.
My lord, the interview in the interview, lordship will
page
find
19A
is the person. They are the persons who were called for the interview.
And your name is at serial number 4?
I was called, and from 31 to 41, these are the persons in the seniority list who were selected.
At page 20 is the select list.
Yes, my lord. 5 persons
people.
were selected. My lord, one at serial number 34, Aradhya Gogoi. Then, my lord,
No. How do you say that the seniority has a role? When the advertisement was clear that it will based upon the marks of 100 marks, of which 40 will be interview and 60 will be performance appraisal report.
So, my lord,
isn't that on the basis of merit?
Yes, it is on basis of merit, but seniority will also have an impact because seniority in the feeder post will be carried by the selected person.
Then why did you participate in this selection? If it is done on the basis of marks, because if you see, shall be made by the number 7.
Yes.
List of successful candidates for promotion shall be made by the committee in order of merit.
Yes.
So
merit.
it is absolutely on merit, not on the basis of seniority.
Agree, my lord.
Very well.
It is absolutely on merit. So merit on in marks in the interview and ACR. So my lord, what if there is no cutoff mark and there is vacancy? There must be some good reason. We do not know. I tried to get the reason for denying me the promotion. I wanted to have a copies of the minutes of the selection meeting. That was not provided to me. Lordship will find that I have asked for those things.
Under the RTI,
No, my lord. Directly to the chairman by filing a representation.
they have not given.
No, my lord.
You only want that?
No, my lord. I want the records to be placed for your lordship to find out what the bank.
Yes,
is.
Mr. Doctor.
And I am retiring on 30th. So, my lord.
My lord, your lordship may give some short time, my lord, as he is retiring on 30th June.
22nd, my lord. Only thing the record will decide if I.
No, it's not the question of record. Here is a case that there were 11 posts.
Well.
There must be some compelling reasons why you have not made them.
Possibly, my lord, he did not do well. It may be so.
Now, if he doesn't do well, do you have a cutoff mark?
That I'll have to, my lord, some instruction I'll prepare.
Because the advertisement, the circular does not say man, any cutoff.
From this circular, my lord, it's not clear whether there is any cutoff mark. If there is a cutoff mark, my lord, if he didn't achieve to that, possibly is out.
But Mr. S. Chakravarti, the learned counsel appearing on behalf of the petitioner, Mr. S. Dr. the learned senior counsel, assisted by so appears on behalf of the respondent number 1 to 4, 1, 2, and 3. Issue notice making it returnable on 22nd of May 2023. As Ms. So-and-so accepts notice on behalf of the respondent number 1, 2, and 3. And so many juniors on it. The learned counsel, the petitioners will serve extra copies of the petition during the course of the day. The case of the petitioner herein is that the petitioner is presently working in
Scale
which capacity?
Scale 3 as manager, scale 3 officer in Assam Gramin Vikas Bank, my lord.
Sales?
Since he's in scale 3 since 2019, my lord.
The petitioner
He's a
has
senior
been
manager in the
working
region.
as a scale 3 officer in the respondent bank. Pursuant to an advertisement dated 12/10/2022, wherein it has been mentioned that the number of vacancies is 11. The petitioner duly participated in the said promotional exercise. However, the respondent bank had only filled up only 5 of the said 11 vacancies. It is the case of the petitioner that the petitioner has been unreasonably and arbitrarily not given the promotion. The respondent and the promotion, that too without there being any cutoff mark in the advertisement. The respondent banks shall apprise this court on the returnable date as to why the case of the petitioner was not considered for the purpose of promotion.
Not so.
15.
Petitioner was working as a Anganabadi worker in their respective post, but my lordship, unfortunately, his appointment was terminated by the authority. Page number 20, my lord, annexure C.
Annexure
C, my lord.
6.
C. Annexure C, page 20, my lord.
20. Okay, in pursuance to the director so and so, done so and so. terminated from her voluntary service with immediate effect. Then, what is your ground? Or
Ground
just
is-
because they have terminated, you approach this court?
No, my lordship, no opportunity was given to me and no show cause issued to me.
Yes, madam. Why haven't you done that?
This is temporary appointment, Lordship.
How do you say so?
I come to the page number 15, Lordship.
16.
Appointment
16.
15, 1-5.
1-5
copy.
is the last portion.
Yes,
14.
15, 1-5. 14 is,
You are referring to annexure A? Or which annexure?
yes, annexure.
Okay, in pursuance to so-and-so is appointed as a on monthly basis, salary appointed will be undergo 3 months training a year, shall be cancelled if fails to undergo training without any reasonable reason. The candidate shall submit the appointment is temporary and at any time without show cause may be released from the duty. Since receiving this order, candidates have to join the duty. Okay, now tell me, Mr. Counsel, one thing. Whether you are appointed pursuant to an advertisement,
Yes, madam.
where have you mentioned? Pursuant to a validly conducted selection process, petitioner was selected for appointment as so-and-so, and the petitioner has been serving since so-and-so with all sincerity and diligence to the satisfaction of all concerned. That's it.
Yeah.
Now you have been, and then was promoted as wait. While discharging the service, the post of AR was upgraded, and the petitioner was promoted as demand in terms with the guidelines providing for such promotion issued by the demand. Now, do you have that qualification?
Qualification SSLC, my lord.
And the HSLC, how can you be there? You have to be an HS for the purpose of worker. You are a helper, it's okay. A helper is HSLC. But why? For worker, isn't it HSLC SS?
In the preliminary stage, I have appointed as a helper, and after 10 years, I am promoted as a worker.
Is it possible to do that? Yes, madam.
Yes.
No, his
As per the
qualification
guideline,
must be there.
If I'm not wrong, the qualification is HS.
Yes.
Isn't it so?
Yes, yes.
And that is the reason why. Now, is he reverted back to the own post? You filed some writ petition, na? And as per the order of his hereby decided to take the honorarium of so and so as Anganwadi worker on so and so. Hence, he is directed to submit a letter of interest to provide her honorarium since service as so and so within 2 days.
And my lordship, annexure D, I have filed a appeal before the authority, my lordship, which is still now pending, my lordship.
Then, why have you come so early? When did you submit? Huh? When did you submit?
9/3/2023.
Page 21.
And what is the other representation? So you have not been given the salary from February 2022.
22.
You have not got.
Not
There the problem arises. Now you are not a helper also.
worker.
Madam, what has happened to her? Because she was otherwise a helper. Helper was done in accordance with the provision. Now you have given a promotion to worker.
Worker.
Now, once you have given a promotion which otherwise couldn't have been done because she doesn't have the qualification. But what about the helper? You have to revert her back to that. No, don't you think so?
Yes.
She may not be entitled to worker, but helper.
Yes.
Instruction is required.
Hmm.
Notice may go. I will take instruction.
Heard Mr.
And Islam.
N. Islam, the learned counsel appearing on behalf of the petitioner. Ms. S. Borua appears for the respondent number 1, 2, 3, 4, 5, 6, 7. So issue notice making it returnable by 12th of June 2023. As the respondent number 1 to 7 is duly represented by Ms. Borua, extra copies of the petition be served upon her by 10th of May 2023. The case of the petitioner herein is that the petitioner was initially appointed as on 26/3/2022 as a Anganwadi worker or helper. Subsequent thereto, in the year 2014, the petitioner was promoted as an Anganwadi worker with effect from 1/1/2013. The petitioner continued to render her service. However, from the month of February 2022, the petitioner have not been paid her salary. Subsequent thereto, on 23/2/2023, the petitioner was terminated. It is the specific case of the petitioner that the termination of the petitioner amounts to a civil consequences, and as such, the petitioner was entitled to a show cause notice. And therefore, the case of the petitioner is that the action on the part of the respondent authorities in terminating the petitioner by the order dated 23/2/2023 violates the mandate of Article 14 of the Constitution, being violative of the principles of natural justice. The learned counsel appearing on behalf of the respondents shall apprise this court on the returnable date as to whether the principles of natural justice were duly complied with prior to issuing the notice, to issuing the termination order, and also as to whether it was necessary to comply with the principles of natural justice in the facts of the case.
16.
None appears on behalf of the petitioner. Please the matter after 1 minute.
17.
Yes, what is your case?
A matter relates to the challenge advertisement issued by the APSC regarding the appointment of assistant accounts officer. Actually, we are in the select list. The select list was since 2000. We are in the select list of the future vacancies. And
Since
2000,
you are in the select list.
of the future vacancies, in terms of the various directions from this honorable court, it was extended till 2006. And
But whether select list remains for such a long time.
But in terms of the directions given by the finance department, it was extended. With the
Finance department have extended it.
Finance department with the director of treasuries. The appointment relates to the accounts officer in the department of treasuries.
Okay, now what is your case?
So what happened? 415 posts have been advertised. Actual vacancies as arisen on 2017 is 464. We are the 1 to 12 petitioners. We are on the select list since 2000. So we are.
So you are challenging some advertisement on the ground that without filling up the selection in pursuant to the advertisement, in pursuant to the select list, which is still ongoing, how can they issue us advertisement?
Because earlier also in 2020, we have filed a representation before the Honorable Finance Minister. Then they have assured us that no vacancies, no advertisement will be issued till our vacancies have been exhausted. So in December onwards, they have issued an advertisement, 23rd. Thereafter, we have filed a representation in the March, the second. So on the without exhausting the list, the names of the petition, we are across the initial age of entry. Initial age is 25 to 38. OPC candidates are there. Five
Now,
years.
tell me, where they have means extended the select list?
Okay.
Because normally this is done under what rules?
The department itself, that with the consensus of the Director of Treasuries, it was extended. And it was given by with the directions of the court also.
Now, understood. What is this advertisement for? Assistant Account Officer in Assam Account Service under the administrative control of the Director of Accounts and Treasuries. This is under what rules?
APSC rules, complete. APSC conducted examination.
Understood. Under what rules? Yes, Mr. Mohanto. We don't find you in the APSC matters. Now you're there. Something must be very big. Yes.
The 1989 rule, my lord.
APSC rules.
Assam Public Service Combined Competitive Examination Rule 1989,
Yes.
which was, my lord, amended, my lord, in 2022. So earlier, my lord, this assistant accounts officer, directly, my lord, there is a requisition given by the department to the APSC. APSC hold a separate examination has been held. Now, as per the amendment, new amendment, the 22 amendment, this is under the CCE, my lord.
What is that?
Combined competitive examination of the that is under, my lord, just like ACS and other officers. I think the same my lord examination, my lord, under that by amending the rule. So now, my lord, their case is that, my lord, they are selected in 2000, my lord, 1999, my lord, their selection was held. Selection was published in 2000, and according to them, there still exists. That is, department can say, my lord, whether it exists or not, my lord, because it is not in our party. Say that without exhausting, my lord, how you can go for interview. That's why they made a pair, my lord, to
No. Therefore, I'm asking you. You selected them.
my lord.
Now, can a select list be remaining in for eternity?
Absolutely not, my lord.
Normally, as I know,
1 year.
select list is for 1 year.
1 year.
Or
Sometimes, my lord, within the year, my lord, if you came before this honorable court, my lord, then normally extend for 3-4 months till. But that also has gone, my lord. And probably now, my lord, they cannot be appointed. They will be overaged, my lord.
Yes. Now, how can they be
23
appointed?
years left, my lord.
Yes,
They were
23 years
selected
back.
23 years ago, they have. So now, my lord, they are challenging the advertisement, which, my lord, examination was held, results also declared, my lord.
No, obviously, because the final examination was to be held on 26th of December 2022. We are in the month of May. Yes, it is there. See?
The preliminary was held in the March. Preliminary was held in the March.
What?
Actually, March 22nd, the preliminary was held.
What preliminary was held to in March? Here it is given, no? Page 75. The tentative date for preliminary examination is on 26th of March.
That is held, my lord.
That was a tentative date, but it was held in the March recently.
Okay, December of 2022. No, first of all, Mr. Kotoki, you have to show me what is your right.
Now, the list was extended as per the terms of the.
Show me that. Where?
The High Court, Honorable High Court has passed order.
High Court extend.
It was decided.
So
It
why
was
not
discussed.
tomorrow let this High Court sit over and say, there's a statute. Isn't it a rule 309 rules?
No, Annexure 14, page 55. It was discussed, madam.
So what? But how can it be extended? Page 55 or whatever may be.
Well,
but is it possible?
Lordship, we go to page 61, para 16.
Page
61, para 16.
This order was passed in 2015. After this order has passed the speaking order on so and so. Where?
Para 16.
1-6.
Par contra, Mr. Goma Learned Standing Council Finance Department submits the select list published in the year 2000 cannot be extended
for indefinite period. She submits that the respondent has already shown considerable accommodation to the recommended candidate by extending the validity of select list for 6 years up to 6/3/11/2006. Thereafter, select list has been extended. She submits the following order of this court. In the speaking order was passed by the respondent number 2 on 17/8/2010, holding that since the select is no longer valid, appointment of the person named in the select list had that to future vacancies will no longer be possible. She submits the respondent had to take a conscious decision not to extend the validity of select list, considering the fact that large number of persons have been acquired eligibility for the post or in question. In meanwhile, considering the appointment to the recommendation candidates from the select list 11/2000 would cause prejudice to the candidate. But the matter was discussed that 6 years. Thereafter, the earlier advertisement of 99 also was discussed in the next bill.
Yes, kindly come to paragraph 23.
Regarding the extent of validity of select is also settled question. There is no manuals can be issued directing extension of validity of select is. Any case for a thing at least to be extended, it must be substituting a thing or least which is not in existence is substance cannot be extended. But earlier also it was extended.
Understood. What is given here?
But this is the fact, it remains. Finding is just but
Then, so that,
2000 to
is this,
2006
Mr. Kotoki, is this a case pertaining to that select list?
2000, yeah.
So then, as of now,
We are not.
then
We have filed
any such direction will be violative of the rights of equal all candidates who have acquired eligibility in the meantime. Then those, your
was
select
discussed-
list doesn't remain.
This was discussion made.
Withdraw, dismiss, which one?
The fact remains that
Yes, Mr.
the honorable-
Barbuzari also wants a right to be heard. Tell me.
My learned colleague is placing the facts randomly. The fact remains, my lord, that it has been discontinued. Lordship may kindly come to page 21. I will take only 1 minute, my lord.
Yes.
Page 21 of the writ petition. That is the select list. There, my lord will kindly come to then, my lord, page 29. Page 29. This is, my lord, for future vacancies.
Further, the following are recommended for future vacancies
For
for
future-
recruitment
for
to the
future
post of
vacancies.
in order prepare.
Then,
Yes.
then litigation started before this honorable court. One of such orders, Lordship will find at page 41.
Yes.
Page 41. Then the operative portion, Lordship may kindly come to page 42. Page 42. Page 42, the last paragraph. Upon hearing the learned counsel for the parties and on a consideration of the pleaded assertions of the petitioners and the documents on record, as well as the interim order dated 7/10/2003 notice herein above, this court considers it expedient to dispose of the present writ petition with a direction that in case the select list referred to herein above are in force or are sought to be extended, and the concerned departmental authorities intend to
Yes,
make-
yes, I've seen it.
Yes,
No,
then-
it's
yes,
okay,
yes.
Mr. You see thereafter what
Yes,
happened.
thereafter, my lord, Lordship may kindly come to page 54. This document ought to have been placed before this court at the very first instance. Page 54. Kindly see, my lord. Peruse the order of the Honorable Guwahati High Court First Censor after examining all the 11 records maintained.
No,
in
this was the subject matter of Justice Bhuiya's order.
Yes, and my lord, by this order at page 54, it has been discontinued.
Huh.
It has been discontinued with effect from, my lord, 2005. Page 54 clearly says. Now this order, this speaking order was not put to challenge. Then thereafter they started another litigation. And that's how my lord has perused page 63. Page 63.
Para 23.
Paragraph 23 is clear. So as on today, there is no subsisting right in their favor. And more so not subsisting right. In fact, they do not have any enforceable right as on date. So therefore, my lord.
Do you need an executive for the right? They don't have a right.
There's a file processing in the department.
And
So
only
in that-
Whatever may be,
and
Mr.
the final
Kotoki.
Presentation 2020.
Nothing doing.
And,
You don't have a right.
Minister has assured us that appointment will be made. But in paras,
Yes,
page
only
17.
thereafter they woke up from deep slumber and they started making representations. And that is why precisely this writ petition is, my lord, founded. They say, my lord, stay the advertisement and consider our representation.
So,
Consider the representation
dismiss.
file in March. One
prayer is the limited prayer.
Mr. Kotoki, for a representation to be disposed of, or a direction for representation to be disposed of, you have to show that you have a legitimate expectation. You don't have a legitimate expectation.
As long as the 464 vacancies, there were advertises 415. 39 vacancies as on 2017 exist.
If your claim is on the basis of a select list of 2,000, sorry, you don't have any right. You have anything else? You have a, but you don't have. Which one? Dismiss, withdraw, which one? Dismissal, it is better. You can go to the division bench. Withdraw, further it is foreclosed.
Short prayer.
Dismissed. Dismissed. Heard Mr. P. Kotoki, the learned counsel, appearing on behalf of the petitioner. Mr.
My lord, I appear for respondent 1 and 2, my lord.
Mr. R. Volpuraji appears for respondent number 1 and 2. Mr. E.J. Mohanto, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent number 3. The case of the petitioners herein is that the petitioners were duly selected on the basis of selected and their names were included in a select list dated 3/11/2000 and more particularly in respect to a list for future vacancies. Their names come in the future vacancies? It appears that the said select list was extended by the authorities from time to time, as would appear from Annexure 3, 4, and 5. 3, 4, 5, and 6. Thereupon, you were a part of the petition Annexure 7. You are not.
No.
Thereupon, it appears on record that a writ petition was filed in the meantime. It appears on record that a writ petition was filed being WPC number 8633/2003.
Lord, the present writ petitioner number 4 was the petitioner at page 41.
Wherein the present writ petitioner number 4
My lord.
was one of the writ petitioners in the said proceedings. The said writ petition, however, was the said writ petition was disposed of by an order dated 31/10/2009. With a direction that in case the select list dated 3/11/2000 is/are in force or is/are sought to be extended, and the concerned departmental authorities intend to make further appointments therefrom, they would do so scrupulously following the order of merit of the candidates therein. It was further clarified in the said order that the direction so given was for the reason that the petitioners had approached this court, petitioners therein had approached the court at a point of time when the select list were valid. It was further clarified that the order should not be construed to be a direction to the respondents to appoint the petitioners, and the issue is left to them to be attended to in accordance with law. It further appears that there was another writ petition being filed in the year 2010, that is WPC number 5366/2010. Which was also disposed of in terms with the directions so given in the order dated 31/10/2009 in WPC number 8633/2003.
And in the second writ petition, my lord, at page 45, the present petitioner number 6, 8, and 9 also stood as petitioners.
It is relevant to mention herein that in WPC number 5366/2010, the petitioner's number
6, 8, and 9.
6, 8, and 9 of the present writ petition were petitioners in the said writ petition. It further appears from the record that on 17th of August 2010, the Director of Accounts and Treasury had passed an order stating inter alia that there shall be no further extension of the validity of the select list dated 3/11/2000 as the said select list had not been revalidated since 3/11/2005. It was further made clear that the list is not valid at the select list dated 3/11/2000 was not valid, and hence it is now to be considered for appointment, and hence it is not to be considered for appointment of the persons in the select list for the post of, what is that, AAO is?
Assistant Accounts Officer.
Assistant Account Officer. It further appears on record that there was another petition, that is WPC number 3276/2013, which was also disposed of by an order dated 11/8/2015. Paragraph number 23 of the said order said paragraph number 23 of the said order dated 11/8/2015. Paragraph number 22 and 23 of the said order dated so and so, being relevant, is quoted herein under.
In that writ petition also, the present petitioner number 9 stood as a writ petitioner.
It is further appears from a perusal of the array of parties in WPC number 3276/2013 that the petitioner number 9 herein was one of the petitioners in the said proceedings. Para 22 and 23 of the said order, page 63, is reproduced herein under. Therefore, from a perusal of the order dated 17/8/2010, as well as the order dated 11/8/2015 in WPC number 3276/2013, the rights, any right which the selected candidate had on the basis of the select list dated 3/11/2000 stood nullified. Full stop. The present petition has been filed again by the petitioners herein, agitating the same claims, now on the ground that the Assam Public Service Commission had issued an advertisement dated 23/12/2022 for filling up the post of Assistant Accounts Officer. Full stop. This court fails to understand when the said select list dated 3/11/2020 had already lost its force, which has been further clarified in the order dated 17/8/2010 and issued by the Director of Accounts and Treasuries, and the order dated 11/8/2015 in WPC number 3276/2013. How can the petitioners herein again re-agitate the same? Under such circumstances, this court is of the unhesitant opinion that the petitioners have no right on the basis of their names being included in the select list dated 3/11/2000 for the reasons above mentioned. And as such, the question of challenging the advertisement dated 22/12/2022 issued by the respondent number 3 does not arise. Next. This court further, now, before concluding, this court further would like to take note of the submission made by the learned counsel for the petitioner, that the petitioner had submitted a representation on
That is 17/3/2023.
on 17/3/2023 to
the
Principal Secretary Finance, Government of Assam. And this court should or ought to issue a direction to the said authority to consider the said representation. A perusal of the above, from what has been already noted here in above, the petitioners have no right whatsoever to claim any appointment on the basis of the select list, which has already dated 3/11/2000, which had already spent its force. And under such circumstances, this court is also of the opinion that the petitioner does not have any legitimate expectation for consideration of their claim. Under such circumstances, the question of issuing a direction to the respondent, is it a respondent? The Principal Secretary Finance? No.
No.
The issuing a direction to the respondent number, the direction to the Principal Secretary Finance for consideration of the representation dated 17/3/2023 does not arise. Considering the above, the instant petition stands dismissed. Now, abuse of the process, how much cost?
poor clients, the poor clients, unemployed people, they are in the roads.
So upon the lawyer then?
Your Lordship,
Heard, Mr.
HP column, madam.
PK Das, the learned
HP column,
HP Gwala,
madam.
the learned counsel for the petitioner, issue notice making it returnable by 26th of June 2023. Steps be taken by way of registered as well as usual.
Obliged, madam.
43,
My please, your lordship. My lord, order, judgment and order dated 29/4/2022, my lord, is yet to be complied.
Complied?
Is yet to be complied with, my lord. No order has been passed, my lord, pursuant to this judgment. And page, my lord, the 12.
Very bad. This is Fazal Ali, Fazal
Yes,
Rabi or something.
Yes, your lord. Correct. There are 6, my lord.
Then what has happened? On 26th, Annexure 3,
No issue, my lord. They are approved.
this is done by
21, my lord, additional commissioner.
So these have been issued, then also nothing has happened.
Yes.
So you have made whom a party?
Commissioner. Commissioner PNRD.
Or Mr.
M. Islam.
M. Islam, the learned counsel for the petitioner, issue notice, it will returnable on same date. Ago order. Next order, same.
Almost
Next
same, but have the direction as 2 parts. First part complied, second part is yet to be complied.
Same.
Same, my lord.
44,
Highly obliged, your lordship.
I know 55,
My lord was pleased to direct the government to take inspection, since they're all inside, my lord, in judicial custody.
My lord, as regard to the inquiry, my lord,
That is what we have reiterated, my lord, that we need 3 months time to complete it. In the meantime, we will take steps, my lord, to seek permission from the authorities so that we can go inside and, my lord, take statement.
Yes, tell me, how is it possible? Under what provision you are going to get hold of those witnesses, more particularly from 3 to 5 or 3 to 8, 3 to 6, from the judicial custody, and then bring him for the purpose of departmental inquiry? How is it possible? They may say 3 months, but how is it possible? More particularly when you have made number 3, who is the prime accused? Why would he say anything against himself or incriminating himself? That too from a judicial.
My lord, we will move appropriate application before the authorities, my lord, and we'll try to, my lord.
How is it possible? Means tell me, give me a reason. How, show me the line. How is it possible to file an appropriate application? Is it possible to get it? Just for example, you have to move the CGM. He's now under the custody of the CGM because till now charge sheet has not been given. So he'll be under the custody of the CGM. So you have to file an application from before the CGM to get him out. How are you going to do this inquiry? Because you see, what, as I could see, Mr. Chaudhary also here, see the departmental manual 2.18 says about 3 months. That is, there is a reason behind this 3 months. The reason springs from FR 53.
Yes.
Because FR 53 says about 3 months, initial period of 3 months. Because you are going to hold somebody out here, keep a person under suspension, a government person, a government service, or the amount of money the government is going to spend, paying 50% or 75% now. Now it is 75%. Now you are paying him 75% without any political work. That is the reason behind why you have it in 2.18. It should be completed within 3 months. There's a loss to the government.
In fact, my lord, honestly speaking, now what has been laid down in Ajay Chaudhary is already implicit in our departmental circular.
Ajay Chaudhary is on 167.2.
167.
Thereby Article 21 was in progress.
Yes, that's speedy trial.
Yes, but our departmental circular
It's
is
based on
the
FR 53. Absolutely.
That is why the 3 months.
Correct.
If you see 53, categorically says about 3 months. More particularly 53.1 2A. It says FRSR. Now, that day I was trying to reconcile the division bench judgment.
Yes.
The manner in which you can reconcile is, if you see Rakesh Paul's judgment of the Supreme Court under 167.2, it says that the person concerned, once the period of 61 days, 91 days, or 181 days, as the case may
Whatever it
be, a person is entitled to default
Default
pay,
rate.
then he may again be arrested. And then he will be entitled to regular bail. You see the last paragraph or the penultimate paragraph of the said judgment. That is how you bring in 22,
Para
of
20.
Arjay 22.
Okay.
That is why
In
last
those
line it
situa- in
says,
those situations.
that is why it says that you can. And then you read the division bench judgment also. If they have the power, they can do so. But if you see again the first part of para 21, for reasons to be recorded, it is necessary.
Perhaps, my lord, that could have been qualified.
Yes.
Because required action. Otherwise, my lord, the wrong meaning can be given.
Yes. So
As
that,
if in exercise of power of review also that can be done.
so all these things needs to be read together.
Yes.
167.2 has to be read with that last portion of that Rakesh Paul, and then reading it, giving them the power, but provided the second part of paragraph 21 has to be taken note.
Yes.
When it says that once you serve the memorandum of charge, then in that reason, you have to give a reason order as to why you want his suspension to be extended.
Or why further continuance is required. Merely, my lord, extension will not.
Do.
A
You
reason
can't
order.
just do the extension. And then you can again exercise 6.1, but in doing so, you will be entitled to again challenge it on the ground of arbitrariness. And if there is no reasons, then automatically, don't you think that Article 14 is it?
Another reason, my lord, why that division bench last paragraph was not called for. The honorable division bench perhaps for a moment might have lost sight of distinction between 6.1 and 6. Actually, court was dealing with a 6.2 situation.
Yes.
But eventually, the direction pertains to my lord. It falls in the realm of 6. Anyway, my lord, we are all human beings.
So I think this is how you have to read down.
Reconcile the situation.
Yeah, because there has to be a reconciliation. I can't say that the division bench is wrong to
Oh,
the
yes.
text. It has to be reconciled in this manner, reading it. There has to be a reasoned order.
And that is what judicial discipline also says.
What do you say?
My lord, the charge against the petitioner is very, very far-fetched. What had happened, my lord? The allegation is that actually from the SIM card which I was holding, from there is no call has been made. Neither really call has been received. My lord, the situation is like this. If there is a tower nearby, supposing we all are sitting in this room, our all signal will go there, my lord. It will catch. That it doesn't mean, my lord, I contacted with anybody. If from the SIM card any phone has emanated or it has received any call, in that situation, there are scope to infer few things. But merely because my number is reflected, it will reflect because the SP's number is very near. I was additional SP, my lord. And my lord, in the criminal case, there is no charge sheet against me till then. Nothing.
And you have been also released on bail.
Yes. No, I was not arrested.
No, you are not.
Not arrested.
You got an anticipatory bail. Because Mr. Dhar, there is a problem. You see, you may say that within 3 months, but is it possible? It is next to impossible because till that person is there, I don't think you can exercise the power being the inquiry officer that let me record his
And
statement.
as your lordship has rightly said, why he will implicate himself?
Why will he incriminate himself and say that, yes, I was there to that effect? And more particularly, when there's a criminal case against him. And okay, let us assume, what is this? What about 1 and 2? Have you recorded their statement? You are saying about 3 months. Have you recorded 1 and 2?
That part, my lord, my instruction.
Only don't say again, no instruction.
No, my lord. My lord, whatever instruction I have received, it is before your lordship. That's the original copy, my lord. My lord, I act on instructions, my lord. I have given them a detailed letter, though this is the instruction that I have received. One thing, my lord, if you go by page 34 of the
my affidavit, my lord. That is the show cause, my lord. Show cause.
Page
Notice
34.
page 34 of 176, my lord. It is now
176.
176 running page. Show cause notice. What my learned senior has just, my lord, has submitted. Para 3, my lord. That is the 176 running page, my lord. The show cause notice.
While on 18/10/2000, so-and-so Sanjit Krishna, APS, Superintendent of Police Assam, took photograph of the question papers of SI recruitment by mobile phone. You were also present there. Then Kumar Sanjit Krishna, APS, handed over the mobile set to Nipu Kupon, to his PS. After that, Rahul Hazarika sent the photographs of the question papers of SI recruit to the personal email of Parosha and informed Saraswama to check the email with the knowledge of Kumar and you. Being a responsible, it was your duty to inform the commission about the crime of leakage of the question papers of SI's recruitment in so-and-so, but you failed to do. Mail the photograph of the question to speak so-and-so with your knowledge, and you neither stopped him nor intimated the APR or the PIC about the leakage of. Thus, you indulge in leakage of confidential information. Understood. These are allegations. But
my lord,
don't you think the suspension, you see, first and foremost, suspension is not a punishment.
Correct.
If it is not a punishment, can you just say that I can keep him out there for suspension till the ending of the inquiry unless you have good reasons that yes, you can complete? Or he may, as of now, temper, but he's outside, he can very well temper. The only thing is, you can very well place him somewhere without giving, which is given out there in Ajay Kumar Chaudhary.
My lord, he is not a, my lord, constable or a small time officer, my lord. He's an additional SP, my lord. Once he is back in office, my lord, he may try to influence, my lord.
He's, no, tell me, as of now, he's outside. Can't he influence? I would have understood. If he's inside, he can't. But otherwise, he's outside. How does it make a difference? Normally, when you are opposing a bail application, you will say that if he goes outside, he will influence. Very well understood. But he's outside.
That is, my lord, he's outside the office, my lord. Once he gets in,
No, why are you keeping him in his office? Put him somewhere else.
Yes, transfer me. In any case,
Because it's not making sense to keep him, because unless you tomorrow find out, because wouldn't that amount to punishment? Because suspension is not a punishment.
Suspension is not a punishment. So, my lord, my humble prayer to my lord will grant us 3 months time. And if we can complete, obviously, my lord, that will be the end of the thing, my lord. We'll have to act on.
But you have to give me a good justifiable reason that you can complete within 3 months. That is why I put a specific question to you. Is it possible? Think as a lawyer, not as just the counsel of the respondents. Is it possible? Because I don't know. You may get him because you are from the police. You can get him. But can you get him out? Can the inquiry officer summon that witness? Is that power being given under Rule 9? Unless you see a civil court is given a power. The Commission of Inquiries is given a power. But is that power given under the rules of 1964? And if it is not, how can you ask even the authorities concerned?
My lord, that is what the instruction, my lord, says that they will get the appropriate, my lord, approval from the authorities. That is, my lord, maybe the CGM, my lord.
Because I'm telling you why. You see, in this 75 years of Platinum Jubilee celebration, you must have seen some prisoners also take part. They had to be brought in by way of some parole. Not parole, there's a
Furlough.
furlough. They had to be brought in by that manner. But that has been done because of the High Court asking them, requesting and the authorities did it. But can that be done for these people? The persons who are in judicial custody? Because that is an aspect which needs to be. Or if you are apprehensive of the fact that these people, this 4% is going to get bail, it's a different aspect of the matter.
I don't have that instruction, my lord. I even cannot.
Well, only one information, my lord. I was not enlarged on bail. I was interrogated and I was never taken into custody.
No. Anticipate?
No.
You have not got
No,
anticipatory.
I was squeezed. I was interrogated, but I was never taken into custody. And my suspension is under 6-1.
That is why he is under 6-1, not 6-2.
6-1.
No, because 6-2 can't happen.
Yes.
You are not arrested.
No. And my lord, the final charge sheet has been filed. My name is not there.
Charge sheet has been filed?
Yes.
You have brought on record?
Yes.
Oh, that I remember.
Yes.
And last time you have.
And only because, my lord, the SIM card which belongs to me, my number is reflected in the tower. That is the only suspicion. It can happen, my lord. Today, my lord, if there is a nearby tower, all our phone numbers will be registered. But that by itself, there is not such there is no phone call between me and Sarosh Sharma or any Sarosh Sharma calling me up or the other accused. But there's not. Only my number was registered in that, location. And naturally, my lord, my house is just near the SP's bungalow at the Karimganj because I was additional SP boarder. Even on marriage, I'm saying that. Thoroughly interrogated. In fact, in page 13 and 14, my lord, at paragraph 4, I have stated that.
Now, Mr. Dole, what is the stage of the inquiry? Nothing.
My lord, on the last occasion, the petitioner took time, my lord. He was supposed to appear, my lord. He took time. That is the instruction, my lord.
What?
Next date is
then have you, if the petitioner is delaying, then have you taken action in terms with FR 53 of reducing his subsistence allowance?
that we have done. I don't have instructions, my lord, but I don't think so, my lord, that was that will give me that instruction.
So you are not, if you have not done that, can you say that you have been, and it is at the behest of the delay caused by the petitioner, the departmental proceedings have been delayed? You have the FR 53, you're going to review.
My lord, which section, my lord?
FR 53.
53, my lord.
Not this one, the next page. On top.
My lord. The rate of journey allowance will be based on the.
So there it says that if there is a delay at the behest of the suspended or delinquent officer,
My lord.
you have to reduce the subsistence allowance. Doesn't it say so? You have not done anything.
No, my instruction doesn't say so, my lord.
Then?
But it says that, my lord, because of him, my lord. Yes, maybe he had a valid reason, my lord, that twice, my lord, IO was appointed, and on his previous assignment, he was, these IOs were his superior officer, or maybe was from the CID. So on this ground, two grounds, my lord, we had to again change, my lord, go for a new IO. And on the last occasion, my lord, he took time that he was not well, something like that, my lord.
But what was on the last occasion? It was fixed for what?
Well, eventually, one Imdadul Hussain Bora, who is IGP security, he was appointed as the inquiry officer on 10/2/23. And thereafter, my lord, he must have fixed dates and all.
Thereafter, what are the dates fixed?
I think after his appointment, only one date was over. My lord.
You must be put to notice about those dates. What is the date fixed for? Huh?
The last date was 22nd 3/22 or 23, my lord. 22nd March it was. Next date was fixed on 3/4/23, that is April. What happened that day, I don't know, my lord.
I think last was 3rd April.
3rd of April was fixed for what?
I think, my lord, after appointment 22/3 was the first day.
First day.
For appearance of parties. Thereafter, he must have said that this is how we'll proceed. So, my lord, now basically the prosecution is to, prove their case.
An application requesting
At this stage, we have no role.
If the defense assistant, he was suffering for chicken pox and viral flu.
That I have seen it. Chicken pox of the defense assistant. That is of last one.
Last
2/4.
Uh,
The PW and the charged officer appeared before me. However, the charged officer had submitted a requesting for allowing a defense assistant during the course of the proceeding. He further intimated in writing that he has been suffering from chickenpox with viral flu and thereby requested. According, the next date is fixed on 3/4. Further, on perusal of the it is found that a few of the PWs in judicial and permission has been sought from the appropriate authority for their examination and recording of the state. It is further noticed that the inquiry of the DPU could not be conducted due to various issues raised by the charged officer. Understand, I would request you to kindly grant at least 3 months' time for the completion of the subject to the approval of the appropriate authority for examination and recording who are present in. Now, this order was passed as far back as on 2nd of April.
My lord.
By the Inspector of General of Police SB. And here it says, if you see the 4th of May,
My lord.
so and so area enclosed wherein it was clearly stated that the inquiry can be completed within 3 months subject to the approval of the appropriate authority.
For examination and recording of the
Ah.
statement.
And what is stopping the appropriate authority to give the permission? Because the request was made on 2/4.
My lord, I'm not very sure whether application was moved, because if I read this line, present judicial custody and also permission has to be sought.
Yes.
Has to be sought, my lord. Whether it
Which
was
presently, and also the permission has to be sought from the appropriate authority for the same.
Same.
This aspect of the matter is found also in the communication of 2/4.
yes, my lord.
Subject to the approval of for examination and recording of the statement of who is presently in judicial custody. Now, if for 1 month nothing has happened, does it show any interest on your part of the authority to complete it? Because the 3 months is subject to,
Subject.
and you can't say that how they are going to get you, these people. Because on the last occasion, I made it specific, my query. The order was very specific, I've asked you.
Yes, my lord.
The court had put a pointed query upon Mr. Dhar, the learned counsel appearing on behalf of the respondent is what is the status of the departmental query? The learned counsel for the response submits that the new inquiry officer has been appointed, and as per his instruction, the inquiry officer has stated that he would be completing the inquiry within a period of 3 months, and of which 15 days have already gone. This court further taking into account Annexure 1 of the additional affidavit so filed by the respondent, which is the memorandum of charge of the show cause dated demand, and the list of witnesses mentioned therein, further inquired with the learned counsel for the respondent as to whether the witness on behalf of the departments have been examined. The learned counsel for the respondent submits that out of the 6 witnesses mentioned therein, the witnesses at serial number are presently in judicial custody. In that view of the matter, this court inquired with the learned counsel for the respondent as to how the inquiry officer can conceive of completing the inquiry when the witnesses so and so are in judicial custody, and whether the inquiry officer would have the power to summon the said witnesses for the purpose of examination of them as a witness. Mr. Dhar, the learned counsel appearing on behalf of the submits that he would require an accommodation for a week so that he can obtain the instruction. So my inquiry was specific to you, and we don't get an answer. Because Mr. Dhar, as you said, please give me 3 months. 3 months from when? Because the inquiry officer is not clear. Subject to the approval of the appropriate authority. The appropriate authority was requested on 2/4, and nothing has happened till 4/5. And my pointed query to you is, can you get hold of those people?
That is what, my lord, the department, my lord, on instruction I'm taking, my lord.
That instruction remains the same. The instruction on 2/4, 4/5, and the present are exactly on the same line. 2/4, the last paragraph, 4/5, the second paragraph, and the last one is again the first paragraph. It's the same. There's nothing, no development for a month. Now, do you have the power to call these witnesses? If you don't have the power, how do you think about completion? Because you have to also think about another very important aspect of the matter. A matter which pertains to what happens in a case where the criminal investigation and the departmental proceedings hinges upon the outcome of the criminal proceedings. Can you keep a person for suspension for such a long time then? That too in a case where you have not arrested him.
So my prayer is very limited, my lord. My lord will grant us 3 months time from today. My lord, if we cannot, my lord, consequential order will follow, my lord. We'll have to, my lord. That is our prayer.
So are you saying that if you don't complete it within 3 months, the petitioner would be reinstated? Are you saying that? As a limited submission which you are making? If you are not saying that, then on what basis do I take it as your word for that?
My lord will keep the matter pending. And
then after 3 months you come up. We have gone 2, 3, but 1 and 2, but 3, 4 and 5 we have not been able. Then what happens?
my lord, I'm giving a statement, my lord, on instruction. We said that we'll complete, my lord.
No, it doesn't say so. Subject to approval of the appropriate authority. And this approval of the appropriate authority has been going on from 2-4. See, what is your instruction? It is clear. With reference to have clearly stated that the inquiry can be completed within 3 months, subject to approval of the appropriate authority for examination of the statements of the PW who are currently in judicial custody. Now, are you saying that the inquiry officer could go there, inside the jail? Is it possible? And then if the inquiry is held inside the jail, how do you bring the petitioner there? I don't know.
Peculiar situation.
Huh? How do you do that? Unless you go before the CCM says that we have no problem, kindly release them. We want to hold him and punish him for that, blindly give these people bail. That's the only way out.
Situation is very, very tricky, man.
And further to that, you see, the power is not given to these people because they are not a court. Remember that. You see, you go to see that power is specific. That is why, just for example, in the Consumer Protection Act, have a look. A specific power is being given to the consumer protection, the consumer forum, saying that the power which is being given to the civil courts for calling the witness is being given. The calling for recording of evidence as per this, which is given out there, is given. For issuance of commission, the power which is there under Order 26 is being given. Those are the specific, all act, it's a creature of a statute. Then how does the inquiry officer do it? Yes, Mr. Borpujari. What do you have to say on this? Is it possible? That is impossible. Because the power is a creation of a statute.
Yes, and the Consumer Protection and other Parameter Act, they provide for power for summoning and enforcing the attendance.
Limited power of CPC is given.
Absolutely. Everywhere it is being given. This power is, however, not given
to an inquiry officer.
Therefore, that day I was taking up another matter, Mr. Chaudhary. That was the power where this person concerned, the Deputy Commissioner, in fact, I will say, had the audacity of issuing a show cause as to why the penalties under Section 7A of the Prevention of Corruption Act should not be imposed upon you
My deputy commissioner.
by the deputy. Mr. Datta was there.
Maybe he's under the impression there is no division of my lord executive and judicial.
No, he's here only. Then I asked him. Then he said, from next time onwards, I'll be issuing notice or doing after taking legal opinion. That is his affidavit. But this is the status. This is the, you see, otherwise this is never going to complete. If you put these people, unless those people get out by getting bail. It's impossible. Chalo. Heard Mr. Ken Chaudhary, the learned senior counsel, assisted by Mr. J. Patwari, and Mr. Ardhor appears on behalf of the Home Department. Hearing complete, judgment reserved. I'll actually, otherwise I would have given it, because here the interplay with all these judgments have to be mentioned. Otherwise it will have a
My lord, as per our information, last date fixed was 3/4.
3/4, and thereafter not.
Meanwhile, my lord, the petitioner's father is also died. Just now we got. So he's in bereavement. 3/4 we have appeared.
3/4 years appeared, but the thing is, the problem, no, obviously, the inquiry officer is in a fix.
Yes. How to proceed?
How does he proceed without the appropriate authority? Now the appropriate authority can't give you.
Deeply.
For admission item 18.
Yes, what is your instruction? Any instruction?
We had filed our affidavit, Lord.
Yeah, file your affidavit.
Yes.
Anyways, I don't think I should take up this matter.
On behalf of the government, Lordship.
None appears for the petitioner. Let the matter be listed after 3 weeks, 4 weeks. Unless these are not matters of suspension pension. Na?
19.
Any matter which is urgent, anybody? Which I should take it up, because you see today I am on a 3F types.
My lord, there is a series where, my lord, the issue involved is whether, my lord, a contractual employee can be terminated from service without following any procedure. Just because there is an inquiry behind our back based on that. In fact, I am covered by one of the Supreme Court judgments where it says, my lord, if there is any inquiry and if the findings of the inquiry was used for the purpose of termination, then, my lord, I am entitled to protection. Direct judgment.
I have also given one judgment on that
Yes.
regarding this matter pertaining to Abhijit International. There, the excise authorities, there was initially, this happened just because of the new Excise Act coming in.
Yes, after 16.
Yes. Now, what has happened prior to that? All the wholesale, the bonded warehouse had to pay need not pay.
When, my lord, no, when the product leave the warehouse,
Then the tax was liable. Now, what was happening is these bonded warehouse, after the 2016 amendment, the new act, to become a bonded warehouse, the manufacturer has to be a part of it.
Yes.
And otherwise, they become wholesale warehouses.
Yes.
So the government took a decision on 27/8/2027. It came from 27/8/2016. That they are going to form a joint team.
But there is a notification. That is not law.
That is not law. But anyways, but that notification is that we are going to have a joint team and we will analyze, find out everything, and this amount has to be paid. And thereafter, whatever happens later on is you are to pay as per the new act. Okay. Now, pursuant to this, the excise commissioner passed an order, and there were many people who made the payments.
Some did not.
All of a sudden, the BIO made a surprise inspection and submitted an inspection report. So-called notices were issued without giving that inspection report.
Yes.
I set aside all the orders of demand, giving them the liberty that I have not touched anything about all these things, but liberty is being given. If you want to take action, but following the principles.
Yes. Same.
And in that case, I have dealt with all the judgments, including the latest judgment of 2022 something. I forgot. Justice Gavai's judgment. It has a different name. What is the name out there? Is
My lord, there is one old judgment. It's a very lucid point, my lord. 1999 2 SCC 21, Radhesham Gupta. It says, my lord, but in a case where termination is preceded by inquiry and evidence is received and finding as to misconduct of a definite nature are arrived at behind the back of the officer, and where on the basis of such a report termination order is issued, such an order will be violative of principle of natural justice, inasmuch as purpose of inquiry is to find out truth of the allegation with a view to punish him, and not merely to gather evidence for future regular departmental inquiry. In such cases, termination is to be treated as based or founded upon misconduct and will be punitive. This is precisely on service law itself, my lord.
no,
Para
in
34.
fact,
There are other authorities
yes.
also, my lord, as the lordship has pointed out.
some Teleknox or something. The name is something so strange. This is 2022 9 SCC or something.
That was the very latest law.
Yes, everything has been taken from, including from the constitutional bench judgments. Then there was a change being brought in by that judgment in S.K. Sharma. There is a something has
Case
been
of
done.
prejudice was brought in.
Yes. So something is then Aligarh Muslim University.
University.
So those judgments have been taken care of. Everything, and then it has been given out there that if you are going to use it, then you have to give it.
Hello, my submission is not convenient. Next Tuesday will it be inconvenient for this series?
I have no other matters.
So today I can argue, my lord.
I am ready. No, what? I am ready if you want.
My lord may kindly take item 23, my lord.
Others may go. Huh?
My lord, I am extremely sorry in respect to item number 45. Kindly take me with
Which one?
45, my lord.
Oh, these will come. I am not a regular member of this bench. I am a pension judge. Anyway.
Not only date, my lord.
My lord will kindly come to page 26, my lord.
26, yes.
Yes. That was the advertisement. Applications are invited from eligible Indian citizen in prescribed form published in the official website for filling up the following position on contractual basis under Mahatma Gandhi National Rural Employment Guarantee Act and Pradhan Mantri Awas Yojana under the Department of Panchayat and Rural Development. So these are the different posts, my lord. In this case, we are concerned with accredited engineer.
Okay.
Then
This
my
is on
lord-
contractual basis?
Yes, appointment was contractual. Then, my
Contractual.
lord, at page 31, my lord. Sorry, at page 29.
Yes.
This is the appointment order, my lord.
Hmm.
The following candidates have qualified for the post of accredited engineer on contractual basis under MNREGA as per written examination. My lord, serial number 318 is the petitioner. No, Janu? Serial number 318, Abdul Karim.
Okay.
Then, my lord, at page 31, this is a letter, my lord, letter of joining. In the interest of public service as newly selected accredited engineer, we'd like to inform you that after successful completion of induction training program, you have been posted as follows. So I was posted as my lord at Nalbari Borketri block. Then, my lord, an agreement was signed at page 32. Lordship would kindly come to serial number 3. During the duration of contract, the engagement of the employment shall be purely on contract basis for a period as mentioned in the order of contractual employment or a maximum of 364 days, whichever is more. Unless terminated earlier, the service of the employee shall stand automatically terminated at the expiry of the contract period without any necessity of the employer giving any notice to the employee and without any liability on the part of the employer to pay any replacement or any other compensation. Then, my lord, then, my lord, what had happened at page 39, all of a sudden, the impugned order was issued. Whereas an inquiry was ordered, right, ordered it is so and so in connection with alleged misappropriation of funds.
Now, Mr. Chaudhary, one thing, after this agreement, there was fresh agreements entered into?
Yes. We have stated that, made that amendment.
And what was the date of expiry of that agreement?
Paragraph 5, my lord, no? Paragraph 5. My lord. That the petitioner thereafter entered into a contract agreement with project director on 5/3/19. Although as per the contract agreement, duration of the contract was for maximum of 364 days. However, the contract agreement of the petitioner has been renewed regularly. The petitioner, without any break from the date of his appointment till the date of the issuance of the order dated, had been rendering his service with sincerity and dedication.
So, where is your second agreement?
My lord, there is perhaps no dispute on that count. What they say, there was an inquiry. In the inquiry, were found to be doing some wrong.
No, understood. But if the period is over,
yes,
you may be entitled for wrongful termination for the period of that period. Could you be entitled for reinstatement beyond a thing if it is a contractual appointment?
No, my lord, no. Technically, lordship is correct, my lord. But what I am trying to submit is, there is no dispute on the count that after that expiry of 364 days, I continued to serve and I was paid.
No. If you are entered into again another agreement, it will be only till date. Just for example, this agreement is from 5th of March 2019.
Yes.
This is for 364 days. It will end on 4th of March 2020.
So, yes. Now, I have followed my lordship's point. Now, if your lordship interferes with the order of termination on the ground that it could not have been done in this manner, then, my lord, whatever was the legal consequences as on that date, it will follow.
Understood. But can this court now extend the period of the contract if the period of the contract was still, just for example?
No, lordship is correct. I am answering that.
Yes.
My lordship may not make any pronouncement on that part. If your lordship says, supposing I establish my case and I succeed persuading your lordship to take a view, the consequences will follow. I have see what has followed. It was for 1 year. How do I extend the period? That might not, that part.
Then this order may be wrong. There is no quarrel. This goes. For that, if the period ends on 5th of March 2022, let's assume 2022, because the last of the contractual agreement was for a particular period of 1 year.
It will for another 1 year.
So if it ends on 5th of March 2022, does this contract can this court say, that yes, you may be entitled for the recovery of salary for this period? Nothing more than that.
No, at least, my lord, if your lordship comes to the conclusion that my dismissal was wrong or termination was wrong, that means, my lord, with reference to that date, they will have to take me back and, my lord, pass a consequential order. Lordship need not say that you extend it, but with reference to that date, they will have to take me back, my lord, and take a call on what they deal with my case. In that case, what they will have to do, they will have to hold an inquiry. For that, I'm bound to be their employee. Then master servant relationship.
No, do you have a right to continuation beyond that particular after the contract period? If you don't have a right to continuation, the problem will be, wouldn't this court, without saying anything, would it be court extending the contract?
No, my lord.
Yes, this order can be held to be bad. There is no quarrel with it.
No, end of the, if my lord will be satisfied with that. If your lordship holds that this is bad, then my lord will take care of our rights. But we have a limited grievance. This order could not have been passed in the fashion, in the manner in which it has been passed. And they are bound to, my lord, follow it up, or else they will have to take me back. Otherwise, also, my lord. If they do not, then we may have a different cause of action. In that case, we'll say why we have a right. Because after regular recruitment, a regular selection process, we are recruited. Now, for alleged misconduct, our services were terminated.
But,
No, I follow, my lord. What is
one problem is, I think you should enclose the last of the contract which has been extended. If you don't enclose that,
or we can, by filing an additional, we can bring on record that. We'll do
bring
that.
on record that.
I want to cite one judgment, my lord.
Yes. Let us see what they say after this.
In our affidavit, my lord, it's already preliminary objection was for maintainability, my lord.
Maintainability for what?
For the second part, my lord. Lordship had already pointed out. The first part is the stigmatic, my lord. The natural justice will come on that stage, my lord. But the second part, my lord, the maintainability of the repetition after the contractual period is over, my lord. This judgment, my lord, Ajay Kumar Halloi, paragraph 12 and 13, my lord, hold that after completion of the contractual period, my lord, repetition is not maintainable.
No, why not?
Contractual period is already over.
Just for example, if the termination is held to be illegal,
my lord,
wouldn't they be entitled to the salary for this period?
My lord, in this judgment, it also, my lord, paragraph 13 may kindly be seen, my lord. May I read, my lord?
Yes.
The result of the foregoing discussion is that the repetition is not maintainable for becoming infructuous and is therefore dismissed, but by directing the parties to bear their respective cost. However, considering the particular facts and circumstances of the case, I direct the respondent authorities not to recover the remuneration already drawn by the petitioner. The interim order so and so vacated. So if lordship will interfere with the stigmatic part, my lord,
No. What is the remuneration the court is speaking about?
that case remuneration is already paid, my lord, after the contractual period.
Now you see that one very nice judgment, Pawan Kumar Dubey, the Supreme Court say,
my lord,
one additional fact can make a world of a difference in applying the facts to a similar facts.
my lord.
Yeah, the remuneration was there. That is why not to recover. But wouldn't he be entitled to the remuneration if not paid?
Till the end of the contract.
That part I'll not submit. I'll leave it to lordship, my lord. But
So then, if that be so, how can you hold to be not maintainable for that period
my
at
lord,
least?
for that, yes, my lord. I'm only respectfully submitting, my lord. My contention is that, my lord, that after the contractual period is over, my lord, he is not entitled for reinstatement. That part, my lord.
That is okay.
That is
That is okay. That he is not
even
entitled to reinstatement because of the fact that the contract was only for a particular period.
My lord.
But till that period was not there.
My lord. If lordship will hold that as the natural
That
justice
period
was
he is
violated,
entitled to.
natural justice was violation of natural justice was there, lordship will remove the stigma, my lord. We don't have any problem. But the second part, my lord, re-employment, my lord.
No, re-employment is another aspect of
Yes,
the matter.
yes.
We are not on
that
that.
aspect may be take care of.
Yes, that cannot be given
My
because that will be extending this.
Yes, yes.
But only thing as of now,
My
this
lord.
is prima facie.
My lord, my lord.
As of now, but however, he's entitled till the end of the contract.
That measured, my lord.
So if that is so, then how can you say the petition is not maintainable?
My lord.
Chalo, you file
You
your
can give-
additional.
I'll file.
I think that is better.
Yes.
Heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by Mr. R. M. Dekka. The learned Mr. S. Doctor appears for the PNRD department. During the course of the hearing, and the learned counsel for this court put a specific the course of the hearing, and upon perusal of the writ petitions, it transpired that the last of the contract agreements have not been enclosed to the writ petition. The learned counsel, senior counsel, appearing on behalf of the petitioner, submits that he would instruct the his assisting counsel to do the needful by filing an additional affidavit bringing on record such contracts which have been entered into by the petitioners in the batch of writ petitions along with the PNRD department. This is the matter again on how many?
10 days, man.
Huh?
10 days.
10. So we'll have it on 29th. 29th.
My lord, there is one series, my lord.
Lordship
I'm
has
not praying for today, my lord. Item 28 to 35.
Yeah.
Sometimes in the next week, will it be inconvenient?
If you want to do it, I have time. I'll normally sit till 5 o'clock.
His lordship has already heard, partly heard, my lord.
Next week, my lord.
Uh.
Next week.
No, next week I can't. If I can't fix it otherwise, because you see, this is I am not a normal bench of these matters, na. So it could be before.
No, lordship's bench.
What matter is then?
My lord, this pertains to municipality, my lord, regularization. My lord, the municipality took a policy decision, Guwahati Municipal Corporation, to my lord within the sanctions time to regularize the services.
Okay.
Now, first, in the first phase, 500 was done. For the second and third phase, the committees were made, everything was identified. For some reason, my lord, the matter was not taken forward.
Hello, we'll have it on some other day when
Yes,
it is
yes.
convenient.
Next week, my lord, any date convenient to lord.
Next week to 9,
maybe
10,
week after
11.
that.
Next week on this week 9, 10, 11, 16th is booked. 18th?
Yes.
Yes. It is
Deep
matter of
Item 28 to 35. Deep
High level.